My lord, may I be permitted to mention my lord contempt application on my lord 18th of September, your lordship was pleased to my lord direct the my lord state respondent my lord to cooperate with the corporation and to decide the matter and sort out the my lord provision for my lord sending the money in favor of the petitioner. My lord, the matter appeared on 27th, but my lord, I was engaged. I couldn't appear, my lord. Thereafter, my lord, next day, my lord, I tendered my apology. Now, my lord, 2014, the matter is pending. In the meantime, they did nothing. My lord, lordship, kindly, my lord, fix a time any Thursday or my lord, updation I am praying for, my lord.
Sorry, madam. Yes.
Regarding item number 121 of the lordship, urgency is the my son's surname will be changed in the ICS admit card. That will be issued third week of January. I have talked with the learned advocate twice. But he said that if lordship allows the matter to on Monday, and they will appear. Unless this is corrected,
Motion.
urgent motion. I am paying for urgent motion
All right, give.
on Monday.
Other side should be there.
Yes, he talked last night.
With regard to item number 49, that is the contempt application, let it be any time today. There is urgency unauthorized consent. I have
From 2 p.m. it will be called on.
My lord, I am free.
249.
Some matters to be placed in the daily list, my lord. Why, my lord? This relates to my lord question dispute in second SLST, my lord. Where we are just shortfall, my lord. These matters has not been heard even once, my lord. Can it be placed, my lord? All the matters are running in the monthly list. Presently.
Yes, I am aware. I have been made aware that there are certain matters.
Yes, my lord.
But then I have not updated because the other matters are going on. This is the reason.
Initially, your lordship is pleased to call for a report.
Yes.
Thought that be also, well, if
But then
any day in the next week, my lord, for subject education and geography.
no, for you it is education geography. For somebody it will be Bengali and history.
yes.
So
Well, can it be, my lord? 6 matters are there.
all right, 14th.
I'm obliged.
My lord, may I have your lordship's kind leave to mention one motion for inclusion, my lord?
No.
My lord, with regard to item number 320, my lord, so the matter heard in a contempt petition, my lord, matter heard by your lordship on several times, the contemptor came before. My lord, kindly, my lord, every day I am pressing my client because of that, your lordship, they have given undertaking before your lordship, they will comply with your lordship's order after, my lord, the dismissal of the appeal. Every day, my lord, I have been, my lord, kindly 320, my lord, kindly any, because of they have given undertaking before your lordship, on the next day they will file the compliance report. So till this date, they have not complied with your lordship's order. That is, my lord, the problem is this, my lord, since 2023, my lord, appeal dismissed by the division bench, lordship's order has been challenged by the, my lord, the respondent. So now every day I am facing the same.
Who is your other side?
My lord, Devjit Mukherjee.
Corporation?
Corporation.
Kolkata Municipal Corporation? What is the item number?
320.
320. Etu bar kore rakhun to. Prior to rising, bring your other side.
Grateful to.
Lord, item number 650, my client do not want to proceed with the
650.
650 the monthly list.
Monthly list.
My lord.
To be mentioned tomorrow. 650.
My lord, may I be permitted to mention one matter? It is in motion stage, my lord. The petitioner has
I
retired.
do not want to know where is the matter. It's in motion. It will be taken up. Why are you mentioning?
It is out. It has gone out of list, my lord. It was.
So you want inclusion?
Yes, my lord.
Ought to have come on Monday.
If I want to mention, my lord, before mentioning, my lord, I am tendering my apology, my lord, not to present at the time of hearing, my lord. This matter is appearing in yesterday list as item number 34, my lord. The applicant not prosecute on this matter, my lord. No, the applicants not prosecute on this matter, my lord.
They will not proceed.
No, my lord.
Item 34.
Yes, my lord.
Yesterday's list.
Yesterday.
What happened?
Can one they did not want to further proceed in this matter, my lord? Can one, my lord?
Yes.
Can one, my lord?
What order has been passed yesterday?
There is a order that can two in respect of can two. They similarly they did not want to proceed, and my lord, this matter is fixed on 30th January of 2026, my lord. So my lord, in
Has
respect
the order
of
been put up in the server?
no, my lord, not yet served, my
একটু রাখুন তো রাখতে বলুন কি বলছে you say write it and hand it over. I'll check up what is there.
This order, my lord, not yet been served,
I have
my
understood.
lord.
Give the number and what is your submission? You please write down over there.
May
Yes.
I be permitted to mention one matter for, for withdraw?
তারপরে
Ma'am,
তারপরে দিতে মানা করুন। Yes, please.
Lordship, may I be permitted to mention for withdraw with liberty to press file?
Why?
Ma'am, certain relevant document have been received subsequently.
Subsequently,
Yes, ma'am.
what is the item number?
Item number 8214.
8214.
Yes, ma'am.
Item number.
Um, the monthly list.
Item number in the monthly list.
The monthly list.
What is the item number?
WP নাম্বারটা বলছো?
WPA number. Item number.
Get ready and come back. Yes.
Item number 572.
1 minute. Yes.
To mention, item number 297 of supplementary release.
Yes.
An approved teacher for salary and.
No, what you want?
Lordship, the restoration application output, I am giving information.
Nothing.
I am seeking leave to move this matter urgently. My lord, urgency is this, my lord. Petitioner appeared as a Hindi teacher, my lord, in second SLST, my lord. My lord, verification has been completed during the time of interview, my lord. She has been ousted, saying that you did not pursue Hindi, Bengali in your graduation level, but whereas the rule says that I have to pursue Bengali in Madhyamik or Uच्च Madhyamik or graduation, the specific terms as stated in the rules, my lord, they are violating, my lord. They have ousted me from the interview. This is the urgency, my lord. Kindly, my lord. The interview is going on.
Interview going on. Tuesday it will appear.
I'm deeply obliged. I shall serve notice to them.
Affirmed copy.
Then, my lord, I shall affirm and then.
Obviously, without affirmation, nothing will be done.
572 non-prosecution.
Today's list.
No, monthly list.
572 to be mentioned.
My lord, may I permit you to mention one matter, my lord? My lord, this is an old matter, my lord. This is filed on 2022 regarding a transfer. Yeah,
What do you want? What do you want?
My lord, for inclusion, my lord. Very urgent matter, my lord.
From 22, the urgency has cropped up now.
No, my lord. I'm from the beginning of the 2022. I am not the advocate. Now, I have the power.
Right. So since you have the power, the urgency has cropped up. You should know.
No, my lord, the petition.
Don't. I am not including matters.
Item number 1676, my lord. The matter relates to the primary education, my lord.
1676.
1676.
Released.
1676.
Give your name, it will be released.
My lord, kindly, my lord.
My lord, may I inclusion in lordship level application, my lord.
Look, nothing.
Application for substitution, my lord. Petition, my lord.
All the list, please.
My lord,
This was my contempt application.
Yes.
The insurance claim that your lordship had directed to be considered in this particular application, which they had failed. Thereafter, your lordship had extended the time for them to consider it and give a reasoned order.
Has an affidavit of compliance been made ready?
Yes.
Copy served?
Yes, we have served them.
Yes.
Yes, my lord, my first submission before your lordship would be that there has been no compliance with your lordship's order of 25th of August 2025. There was a particular time that was mentioned there. They have not complied with that timeline. So the contempt really remains. But your lordship had extended the time for them to go ahead and comply with your lordship's order of 25th of August. My lord, if I may just beseech your lordship to have a look at page 100 of my contempt application.
What does the compliance say? Page 16, I can see hearing regarding such and such on
That given a
16th
hearing,
of
now
December.
they have passed an order.
Where is it? 17?
The order is not annexed, your lordship.
Did you serve?
Yes, order is there. Order is there.
You should have annexed it.
Your lordship, I think the order was served on the same day this was being made, so it not come.
Give a copy.
I don't have that immediately, but
I have a copy, my lord.
Please let me see.
Your lordship has a look at it. That I should have filed that by way of a supplementary affidavit to show that this is an aid of the contempt. For that, I'll have to show to your lordship your lordship's order at page 100 of the contempt application. Wanted
Yes.
them to consider a particular representation which restricted my scope of consideration apropos the insurance claim from X number of villages to 55 villages. So that was what the order really was. Now, in consideration on 23rd December, they passed the order saying these 55 villages will not be able to consider.
because you had raised the claim earlier in respect of 100 and odd villages. Therefore, these 55 villages are not the subject matter of the insurance claim. That's not your lordship's order, my lord. They've done this only to show that this is going to become a fresh cause of action, therefore file again.
It is.
My lord, please have a look at page 100 once.
I have seen that, but
My lord,
this
specific direction was
appears to be at least 4 pages order. Now, what is there in the pages, I do not know.
correct. So I'll just show one line, my lord, from that, because your lordship's order was that they will consider my representation
No, but then
at
I don't
pages
think I'll
570.
entertain. Please come. An affidavit of compliance has been filed in court. Stuff. A copy of the order passed by the insurance company on 23rd December 2025 has been handed over by the learned advocate representing the petitioner. Stop paragraph. The petitioner is aggrieved and dissatisfied with the manner in which the contender acted for complying the direction passed by the court, comma. I am afraid that the legality and validity of the order passed by the authority cannot be gone into in the contempt application. Stop. The same gives rise to a fresh cause of action. Stop. It will be open for the petitioner to challenge the said order before the competent forum in accordance with law. The contempt application stands disposed of. Who is your other side?
On behalf of the state, my lord.
Yes.
The issue, Malota, I have been deprived from getting the 2 increment on acquiring Malot PST. This is the short issue.
Did they reject your claim?
Yes.
Where is the rejection?
Malot, rejection is page 33.
Yes.
Have taken grounds of Control of Expenditure Act and copy of approval. Neither of this copy of approval is very much there. I'm an approved teacher. I'm working since 1996. This year I am going to retire. And Control of Expenditure Act, there are plethora of decision of this court that Control of Expenditure has no manner of application in my case. Malota, may I place the facts? Malota,
Did you obtain any prior permission from the school or anything?
yes.
Where is that?
School has given me, Malota, no objection. Kindly come to page 22.
Yes.
Page 22 is the school has allowed me to pursue my PhD degree, and Malota, I completed February 2015, I completed. Then I have made the prayer for Malota giving me the 2 increment. Malota, I am a honors graduate teacher. I also Malota master's degree holder. I am getting the higher scale of pay. And Malota, may I cite the judgment, Malota, on this issue?
No, page 22, the school permitted you, right?
Yes.
Thereafter, you obtained the degree.
Yes,
Where is it?
that is, Malot, kindly come to page 26.
26 PhD.
Yes, as it is a date of publication of the result.
Yes, 2015.
I got the Malot, the result was out in 27 February 2015. And the convocation, Malot.
From 2008 till 2015, you took time?
Yes.
Kindly come to page
1 minute,
58.
I'll hear you.
And
yes, 26.
Page 26 is the Malot date of publication of result, and certificate convocation on the basis of convocation, page 28. Though that convocation is no more material, Malot date of publication of the result. It is December 2015. Now, Malot, I make the prayer for granting me the 2 increment on the basis of my PhD. That was ultimately, Malot, forwarded by the school authority, repeated occasion. Contemporaneously, I have made the prayer.
But ultimately it was decided in 2021 by the DI by sending this email that this
All right. Yes. Now show me what you want to show.
Malot, kindly consider. First, my lord, kindly consider the government had issued a Geo fixing a cut-off date saying who are entitled for getting this to increment prior to the promulgation of control of expenditure. May I read this? The second paragraph, very second paragraph, kindly consider the relevant portion. In view of this provision and in order to accord equal opportunity to all such teachers, headmasters in the academic interest without any privilege and prejudice to any one of them, government in the school education department has decided that the teachers acquiring postgraduate degree after having had the basic qualification of honors degree in the relevant subject and subsequently improving their qualification by acquisition of PhD degree in relevant subjects, or those who were appointed with such higher degree in the above mentioned subject in their possession after having acquired honors degree in the regular course and then PG degree in the relevant subjects shall get two additional increments from the date of convocation on which such degree is or was awarded. The benefit in terms of 12.5 of Geo such and such that open 1998 is extended up to 18 August 2005 as cut-off date, that is till before the publication of the Control of Expenditure Act 2005. All such pending cases can be disposed of accordingly. After this cut-off date, all the cases cannot be considered for getting their PhD degree. These particular order as well as the applicability of the Control of Expenditure has come into consideration before this honorable court. I am placing that there. This is the very first paragraph, the facts has been stated. Because it is completely applicable in my case. The petitioner was appointed as an assistant teacher in language group in Khagra Gurudas Tarasundari institution. His appointment was approved as an assistant teacher in the state school with effect from 10 September 1991. At the time of appointment, his educational qualification was BA Honors BT. I am also BA Honors. The said educational qualification of the petitioner was recorded in the approval letter. Subsequently, he enhanced his qualification by acquiring master degree in English. Higher scale of pay admissible to the assistant teacher having master degree was also granted to him after he acquired master degree qualification in the relevant subject. The petitioner further enhanced his educational qualification by obtaining doctoral degree in English from Rabindra Bharati University in 2009. The doctoral degree was conferred upon him in convocation held on 8th of May 2009. After obtaining the doctoral degree in January, he claimed two additional increment as per RUPA 1998. The petitioner's prayer for grant of two additional increment having been rejected by the District Inspector of School AC Murshidabad on 20th of February 2012. The petitioner has come before this court with this writ petition praying for quashing of the impugned order passed by the District Inspector of School. Follow the observation of the Honorable Court. Let me now consider as to how far the concerned District Inspector of School was justified in passing the impugned order in the facts and circumstances of the instant case. On perusal of the impugned order, this court finds that the petitioner prayer for grant of two additional increment was rejected by the District Inspector of School by holding inter alia that he is not entitled to two additional increment in terms of geo number such and such, the geo that I have referred. Let me first of all consider as to what extent West Bengal Control by Expenditure 2005 or those two geo dated 27 February 2009 and 15 February 2012 stand in the way of grant of incremental benefit to the petitioner in the facts and circumstances of the instant case. Government order dated 27 the 7th of February 2009 does not impose any ban on grant of such incremental benefit to the petitioner who achieved doctoral degree. Of course, the government order dated 5th of January 2012 imposes ban on grant of such incremental to those teachers who acquire doctoral degrees after the
You go to the particular paragraph. Do not read out the whole judgment.
My lord, I'm pleased. My lord, paragraph 9, kindly consider. The Control of Expenditure Act has been specifically dealt with by the court. Paragraph 9. My lord, may I read?
Yes, what else?
Yes, my lord, here the court has held that there is no provision in the Control of Expenditure which will bar, and there will be no classification in between the same class.
Yes.
And my lord, that particular GO has been set aside by the court. And thereafter, this judgment was followed repeatedly. My lord, I am placing. Kindly consider here the
Yes.
same issue. Here is also, my lord, the quoting the same GO and applicability of Control of Expenditure Act has been, my lord, referred, and the prayer was rejected. The court referred the judgment that I have cited, and my lord has directed to pay interest as well as cost.
Yes.
Yes, my lord, considering this as it has been settled by this honorable court, my lord, this order is not sustainable. My lord, I am only praying late because I am going to retire. My lord, let the authority be directed to confer that benefit to.
All right. Yes.
And even even the Control and Expenditure Act doesn't have any application in this matter. But
doesn't have.
As my learned friend contained, my submission before your lordship, his rights come from Rule 12.5 of ROPA 1998.
1998.
Therefore, the date of date of the decree is very important when he acquired the decree. Doctoral degree acquired by the petitioner on 9 December 2015. Page 28. And in view of ROPA 2009, there is no provision for such increments. And
2009,
which is with effect from given effect from 1st January 2006. There was no way he is entitled. And my learned friend has shown.
Rejection mentions about the
Yes, might have.
No
That's
question
why.
of might have. You have to restrict your submission to the grounds of rejection. You cannot add up new grounds now.
No, my lord, I am on the basis of an order passed by this honorable court, on the basis of an order passed by this honorable court, wherein my learned friend has contested on behalf of the state. In that, it's a division bench order, my lord. May I?
Page 33 is the rejection.
Page 33 is rejection.
All right. By the way, where is the approval of your appointment?
Yes. I'm sure.
Only 2 grounds have been taken.
Kindly
Approval of
consider
appointment not given.
approval is at page 20. 20. TI had approved.
'97.
My lord,
Your name is
My lord, that is serial 4,
Ashit Sen.
9th of
Yes.
November 1996.
Hmm.
With effect from 9th of November 1996.
October 96.
Yes, sorry, my lord, October 90.
Yes.
And thereafter, my lord, page 21, this is the, my lord, I was allowed the higher scale of pay since my appointment. Because I am a master degree.
Postgraduate scale of
Yes.
pay you are given. All right. Right. So two grounds of rejection. One is the approval which the petitioner has annexed, and second is the application of the Control of Expenditure Act. It doesn't say about any ROPA, nothing of the sort. How can you raise this issue?
Since it's only once a mail, my lord, two objection has been quoted, my lord. But I don't find any order passed by the.
Objection. This is the reason for
This is
which.
the reason.
Then
But
In the
DI,
case of-
DI ought to have quoted the relevant provision of ROPA 2009.
he has not done.
He has not done.
You
Apparently.
cannot rely on
But
the
but my lord, but the law, my lord, kindly once consider this judgment, man.
No, the law is very clear. You have to specify the grounds, which you have not.
Cannot improve in
But kindly once for my sake.
The
Once for my sake,
petitioner,
petition
no,
this
sir.
judgment, man.
The petitioner is aggrieved by the objection raised by the District Inspector of Schools, Secondary Education, Kolkata on 26th August 2021, rejecting the petitioner's prayer for, not rejecting, disallowing not disallowing, objecting to the petitioner's prayer for approval of 2 additional increments for acquiring PhD degree in Bengali. Stop. The first ground of objection is that copy of the approval of appointment letter issued in his favor and second is the Control of Expenditure Act, 2005. The teacher may not be accorded PhD allowances within bracket 2 increments. Stop. The petitioner has annexed the copy of the approval of his appointment issued by the District Inspector of Schools, Secondary Education, Kolkata on 8th September 1997. Stop. The petitioner's appointment stood approved with effect from 9th October 1996. Stop. He was appointed with BA degree within bracket honors in Bengali, and he was teaching the subject Bengali. Stop. The petitioner thereafter enhanced his qualification and attained postgraduate degree, and later on he obtained the PhD degree. Stop. Next. Though the petitioner was accorded higher scale of pay on account of acquiring postgraduate degree, but the 2 additional increments upon acquiring PhD degree has been objected to. Stop. Paragraph. Learned advocate representing the petitioner refers to the government order dated 5th January 2012 issued by the Joint Secretary, School Education Department, Secondary Branch, wherein a particular cutoff date was published for providing the 2 additional increments. Step. The issue as to whether a cutoff date can be fixed for providing additional increment to PhD degree holders came up for consideration before this court in the matter of Chaudhuri Moniruzzaman spelling versus State of West Bengal and others, reported in 2012 5 CHN 598. Wherein the court was pleased to hold that the government order dated 5th January 2012 imposing ban on grant of incremental benefits to teachers acquiring PhD degree after 18th August 2005. That is the date before publication of the Control of Expenditure Act, 2005 cannot be retained on record. Stop. The court was pleased to quash the government order dated 5th January 2012. The court was pleased to direct the authority to grant 2 additional increments with effect from the date when such doctoral degree was awarded to him in the convocation. Stop. While deciding the aforesaid issue, the court observed that the authority cannot create subclassification amongst teachers who acquired PhD degree prior to the cutoff date and the teachers who acquired the degree after the cutoff date. Stop. The same is not only arbitrary and irrational, but also does not have any nexus with the object to be achieved. Stop. The petitioner also relies on the order dated 9th July 2013, passed by the court in WP number 22506 within bracket W of 2012. Shankunath Pramanik versus State of West Bengal and others, wherein the court was pleased to follow the law laid down in the matter of Chaudhuri Moniruzzaman within brackets Supra. Stop. The court was further pleased to direct grant of interest on the arrears due to the said petitioner and also imposed cost upon the authorities. Stop. Prayer has been made by the petitioner to direct the authority to make the necessary calculation and disburse the amount on account of 2 additional increments at an early date, as the petitioner is due to retire from service.
This year, 2026.
When?
December 2026.
So you have 1 more year. In December 2026. Stop. The aforesaid submission and prayer of the petitioner has been opposed by the learned advocate representing the state respondents. Stop. The learned advocate for the state, however, contends that apart from the Control of Expenditure Act 2005, provisions of ROPA 1998 and 2009 ought to have been taken into consideration by the authority for deciding the prayer of the petitioner for grant of additional increments. Stop. The aforesaid submission of the state respondents cannot be accepted by the court. Stop. It is settled law that the authority cannot raise new grounds objecting to the prayer of the petitioner. Stop. The authorities ought to restrict their submission to the grounds which are already impugned in the writ petition. Stop. The respondents have not filed any affidavit in the matter.
Yes,
Stop.
it's a motion stage, my lord, today, first time.
Right. The matter is pending consideration before the court since July 2022. Stop. Next. In view of the above, as it appears that the law has already been settled in this regard, accordingly, similar direction is being passed herein. Stop. The objection raised by the District Inspector of Schools objecting to the grant of 2 additional increments to the petitioner stands set aside. Stop. The District Inspector of Schools, Secondary Education, Kolkata is directed to take steps to accord 2 additional increments to the petitioner on account of acquiring his PhD degree on and from
So February 2015, the date of publication, page 26.
convocation date
Convocation is my lord,
9 December.
on and from the date of convocation of the PhD degree on the petitioner, that is 9th December 2015. Stop. Necessary calculation shall be made by the authority at the earliest and the additional increment shall be disbursed positively within a period of 16 weeks from the date of communication of this order.
I'm getting this.
This
But,
service
since-
is taken on record.
But since my lord has been pleased to dispose of this matter and in the motion stage, but kindly once, my lord, for my sake, kindly consider this order.
No, sorry, sir.
But kindly one paragraph, only
Uh,
one paragraph of this, it's a division bench judgment, my lord.
No, nothing doing. Next.
Kindly record my submission, my lord, that my lord, I beseech your lordship, my lord.
No, but then you're recording your submission.
I didn't disturb your
Which
lordship.
is not a question of disturbing, since it is not one of the grounds you are saying, ROPA and everything.
But not quoting the other aspect of the law.
Yes.
The petitioner doesn't have any right to get the increment. It's a settled law even in this judgment. That's why, my lord, I beseech your lordship to once.
Not quoting means what? Why will the petitioner quote? It is for you to raise objection.
No, but in this order, it has been clarified. Although the act on the basis of which his prayer has been rejected may not be sustainable, but there are other reasons why the prayer of the petitioner should be rejected.
The authority has not taken those grounds.
Then, my lord, kindly direct the authority to consider afresh, so that all the law and all the settled law can be considered. Only for quoting, not quoting the relevant provision, although that has been settled by the division bench of this court.
Yes, but then
kindly
will
see
you
once kindly see one. Let me just
देखिए,
division bench judgment kindly
learned advocate for the
last
state
paragraph.
respondents relies on the order passed by the Honorable Division Bench on 24th of April. What is the date of the order?
Yes,
5th of April.
না ওটা 2019
2019 2019 in MAT 961 of 2017 এটা কপি করে নেবেন তো State of West Bengal and others versus Chandra Bhushan Dwivedi and another. Which portion?
this page last portion onwards. ওরই ওটা দেখি
যেটা রিলাই করে পেয়েছি সেটা
দেখাও
আমি আপনাকে দেখি
আর দেখতে দেখতে
তুমি এটা ইনপুট করবে কি করে
এটা দশটা বলছেন রাস্তা তো দিয়েছে এইটা এই দুটো বাউন্ডারি রিজেক্ট করেছে এটার অ্যাপ্লিকেশন নেই আর এটা ঠিক আছে
But then in this judgment, where is the date when the teacher obtained the degree and everything? Nothing is there. It is only ROPA 1998.
yes since the provision as laid down by the ROPA 1998 has already been repealed by 2009
Right.
On and from 1st January 2006 and since his date of convocation is much
Later on.
later therefore he is not at all entitled to on this ground.
But then he took admission in 2008 only, when the 1998 ROPA was there.
But ultimately, when he obtained the degree,
Maybe
date of convocation,
the date of convocation was not there in 2009 Act. It was there in the 1998 Act. He, when he took admission, on that day it was applicable.
but the relevant date is the date of convocation.
Here, nothing is mentioned, isn't it?
Well, kindly record that one. I've relied on this judgment.
Acha.
Or the DI may be directed to
So and so.
disposal করে দিতে বলছে to
But your lordship may give some observations, my lord, and direct the TI to, my lord,
And
to relook the matter.
in the appeal.
another similar order passed by the same division bench, my lord.
Wherein the Honorable Division Bench held that as the appellant sought for the additional increments relying on ROPA 1998, which ceased to exist when ROPA 2009 came into operation. Accordingly, the additional increments cannot be paid to the petitioner. Stop paragraph. In Chandra Bhushan Dwivedi, within bracket Supra, the date of the application for the date of seeking prior permission for pursuing the PhD degree is not mentioned. Stop. In the instant case, the petitioner obtained prior permission for pursuing PhD degree when the 1998 ROPA was in force. Stop. The petitioner may have obtained the decree later on, but the benefits ought to be allowed to the petitioner, relying on the law which was prevailing on the day the petitioner started his doctoral course. এটা যেখানে রেসপন্ডেন্টের সাবমিশনটা বলা হচ্ছে সেইখানটাতে দিয়ে দেবেন।
হ্যাঁ দেখি পড়েছিল আবার since no affidavit has been
I have opposed all your submissions. So since no affidavit.
Rule 12.5 has been considered by your lordship, my lord, and yes, my lord, this last part, my lord, 3 paragraphs of Chandrabhushan case, where it is held, my lord, that Rule 12.5 of Ropa 98 entitles the holder of a doctorate degree to ask for the benefit of 2 additional increments from the date of convocation. When the convocation was held, 1990 Ropa has ceased to exist. Without a corresponding provision in the new Ropa, a division bench of this court by a judgment as when so in Gautam Ghosh observed that since the rule had ceased to exist on the day of the decree was awarded, the petitioner must be held to be ineligible to the benefit claimed by him under Rupa 98. Your lordship has
But
considered
the
this.
day I have recorded that the law prevailing on the day of starting the course will be
That should
applicable.
be the relevant date.
Yes. Number
The
2,
date of
please.
convocation.
Now call number 2, please.
Lordship. I'm sorry, my lord.
Lord, I am appearing in this matter on behalf of the petitioner led by Mr. Devasis Basu. I am paying for only 7 days time. It is changed my.
And for the state.
The matter was mentioned for upgradation
Without notice, my lord. No notice.
without notice, and assuming the matter has been upgraded, now you seek adjournment. I am not going to grant adjournment. What is the matter about? Please place.
It is a
Prayed
matter
for
of
higher scale of pay.
higher scale of pay.
Yes. Where is your prayer?
The commission has not been made a party, though he was appointed through commission. Page 9, 8, starting from 8.
Page.
Please come. The petitioner claims higher scale of pay on account of enhancing his educational qualification. Stuff. The prayer of the legal representation made on behalf of the petitioner is pending consideration before the respondent authorities. Stuff. Without entering into the merit of the claim of the petitioner, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Barakpur, to consider and dispose of the petitioner's prayer seeking higher scale of pay in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties for production of documents in support of their respective stand. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the parties. If the prayer of the petitioner is allowed, then necessary consequential steps shall be taken by the respondent authority. Disposed. What is your name? What is your name?
অরুণ বন্দ্যোপাধ্যায়।
ওনার নামটা লিখে দেবেন।
I don't know, within 8 weeks.
12. Milord, I am for the petition.
Yes.
Milord, this is relates to transfer of our Milord assistant teacher. Milord, the petitioner applied through Milord Utsossi portal. Milord, it has been backed by the DI to the school. Milord, showing Geo 9 of 2020. Milord, Milord, thereafter, Milord, the school, Milord, page 27 kindly comes to page 27, the last paragraph. School again, Milord, forwarded the same, clarifying the DI's rejection, that it has been stated by the school that hence it has been clarified that the aforesaid office memo number such and such is not applicable in transfer case of the petitioner of the school, as the substitute teacher in the same subject is available in the school under the aforesaid terms and conditions. The transfer application of the Krishna Prasad Chakraborty of the school is further forward from the end of the school authority for favorable consideration. This was done by the school again, Milord, Thereafter, the application has been forwarded by the school to the DI. It is pending before the office of the DI since then.
The petitioner's application seeking transfer is alleged to be pending consideration before the District Inspector of Schools, Secondary Education, Purbo Medinipur.
At Tom.
Yes, without entering into the merit of the same. DI এর কাছে pending আছে, DI এর কাছে pending আছে, transfer application disposed.
Time for secondary board will not. Yeah. Without any notice, my lord, matter has been uploaded. Even
And then when the matter is taken up, nobody is there. Are you there?
My lord, I have been, my lord, I'm appealing for the school, no copy has been served upon us also, my lord.
No copy has been served.
Although there was, এটা তোমার 11
No, no. 4 নম্বর item.
সীমামণি,
হ্যাঁ,
Yes.
ডিটেকশন ছিল। নোটিস করেনি কিছু করেনি না।
since my lord we are following the cost title, my lord, it came
নোটিশটা কোথায় আছে? আপগ্রেডেশন নোটিশ দিয়েছে? নোটিশ দিয়েছে না? ঠিক আছে, আপনি স্লিপটা এতে ট্যাগ করে দেবেন। The matter has been mentioned for upgradation citing urgency. Stop. At the time of call, none represents the petitioner. Stop. Learned advocate representing the board and the school.
my lord, since my lord no copy has, I cannot file my wakalat now, my lord.
All right, you are for the school.
Yes, my lord.
Submits that the matter has been upgraded without providing any notice without serving any notice to them. Stop. Learned advocate for the school submits that the copy of the writ petition has not been served upon the school. Stop. As the petitioner remains unrepresented, the writ petition stands dismissed for default. Next.
Item number 12.
I've heard the petition and led by Mr. Sudeep Goswami.
Time for secondary board will not.
It's the transfer application pending before School Service Commission. Transfer application made on 7 July.
Page 21.
School Service Commission, it is pending.
Page 21, my lord.
আচ্ছা, কমিশনারের কাছে পেন্ডিং আছে ট্রান্সফার অ্যাপ্লিকেশন।
Ground of, my lord,
And divorce.
ground of divorce.
Special ground, that is.
এটা একটু নিন। না,
Disposed. Next.
Item number 6.
Item 6 I am.
Okay.
I'm for the School Service Commission.
But only one request, your lordship, the prayer that has been advanced by the petitioner in this petition, but I don't know whether how far it is feasible to.
Don't press.
I am duty bound when I have taken the brief. No objection.
It show cause as to why he will not be dared to offer appointment letters since the petition is qualified. I also filled up the online application of 2016. So it goes.
That this is the result which was of date 2011.
Yes.
Valid up to 2018. Normally it is permanent. Now the issue is, I did not get any call letter.
In the 2016 process, 2016 has been set as
This
nullified.
is upper primary.
All right,
upper
upper primary.
Yes.
Huh?
I made a representation at page starting from page 17. But actually, I am really in a dilemma how to place the petition. What is there in the petition and how I have to place, I am really in the dilemma.
Place করিস না
Yes, don't place it. It's as simple.
And not
as
one matter, my
this.
lord. In fact, has three matters today, where he will have the same delay.
No. I have, no. I have taken no objection in this matter, my lord. The petitioner has
Doesn't
come.
matter. But then 2016 recruitment process.
This is upper primary.
Upper primary. What is to be done now? All vacancies have been filled up or something. of
Yes,
that sort.
it is that matter.
And he has not been called for interview even.
No, I have not been, and that is my
That means
case.
you are unsuccessful. It goes to show.
That is my case.
Please come. The petitioner alleges that he participated in the 2016 recruitment process for appointment of assistant teacher in upper primary school. He claims that as he was successful in TET 2011, he ought to have been issued appointment letter. Stop. Fact remains that the petitioner was not called for interview. Stop. The interview panel which was published expired in the meantime. Stop.
Not the interview panel expired. The main panel has expired.
Achha, the main
The
panel.
interviews were held in 2021.
Achha, the panel which was published by the commission expired in the meantime. Stop. The fact that the petitioner was not called for interview suggests that the petitioner was an unsuccessful candidate in the recruitment process. Stop. Next. In view of the above, there is no scope to direct the authority to issue appointment letter in his favor. The writ petition fails and is hereby dismissed. And dismissed.
Grateful.
I appear for the petitioner in this matter. House rent allowance is an issue, my lord, was considered by your lordship's court. My lord, whether the husband is working in a private organization or not.
Where is your husband working?
Tata. Therefore, he is in Jamshedpur. I am staying in Calcutta.
All right. Who's for the state?
Lordship, I am appearing for the state respondent. Matter has come in the list suddenly, Lordship, without notice.
Page 91 is the judgment of the Honorable High Court.
Been served, Lordship.
Why don't you serve notice?
I'm not ready.
Mentioned we need to upgrade it automatically.
I'm not ready with the instruction, Lordship. Kindly give me at least two.
Parimesh Babu, বলছি automatically upgrade হয়ে যাচ্ছে।
fact, I was the advocate on record at that point of time. My client made taken no objection.
And but then you mentioned prior that
Objection just after publishing the monthlies mistakenly. That is why I am here. I am tendering apology for wrong mention.
2023, Lordship.
so it is not that it has come automatic.
No,
It has
no,
been
no.
mentioned.
He has not done anything.
I have
Taking
not
the
done
change
no-
from the client, my lord, he has not done anything.
And that is why my client took
He was
the
a very sincere lawyer, my lord. He has applied, my lord. He has made a prayer.
Anyway, yes.
All right, it is
Page
covered by the
91.
judgment of this court, my lord, where the court had said, my lord, this circular.
May I
will
take
not
your
be
lordship kindly?
Well,
Kindly don't take me Amit.
All right, yes.
Yes. But the issue was whether the house rent allowance should be deducted or not. That issue has been considered by Honorable Justice Mantha, my lord. That page 91 is the judgment, where his lordship was pleased to hold that no, that particular circular does not apply. Particularly, that does not apply to the university and the colleges. Secondly, it is a circular, my lord, which is not to be applied to the school education department. And his lordship relied on the Mousumi Vishwas's judgment earlier, and my lord, where the original those circulars were not applied. And finally, the honorable court has held that do not apply those, give the all areas, those have been deducted on account of the house rent allowance, that is from January 2018 as against the petitioner, and the current salary with a house rent allowance should be paid to the petitioner. My entire house rent allowance has been withheld, given 0.
Withheld from when?
From January 2018. And judgment has come out in 2022. But I have filed a writ petition in 2020.
Yes, but then did you approach the authority
Yes,
for
the
release?
authority applications are there, representations are there, my lord. My lord, my school also, my lord, has forwarded the representation. Those are the page 990.
And previously you got it.
Previously I was getting.
Acha, the house rent allowance of the petitioner has been withheld from January 2018, allegedly on the ground that her husband receives house rent allowance from his employer. Stop. The husband of the petitioner is working with a private organization and does not receive any house rent allowance from the
No,
state.
my husband is working.
State.
Not from the state. From my employer, I am getting, but I am staying in Jamshedpur.
ঠিক আছে?
Husband is separately getting. I think.
HRF from the state. Stop. The issue as to whether the spouse of the employees who receive house rent allowance from their private employer would be entitled to receive house rent allowance from the state has been conclusively decided by a coordinate bench of this court in the matter of Moushumi Biswas
This judgment has been relied on
and
most.
another versus State of West Bengal and others on 16th March 2021 in WPA 1389 of 2018. এটা একটা রিপোর্টিং আছে একটু দেখে নেবেন তো reported in blank. Stop. The aforesaid the ratio laid down in the matter of Moushumi Biswas within bracket Supra has been consistently followed by the courts. Stop. One such order is annexed to the writ petition dated 27th June 2022 in WPA 15667 of 2021 within bracket Shumi Chaudhary and others versus State of West Bengal and others. ঠিক আছে? Stop. Paragraph. Yes, your submission.
Lordship, I have not received the instruction till.
Learned advocate for the state respondents is not ready with any instruction. Stop. Paragraph. As it appears that the issue is already settled by the court, accordingly, similar order passed in the matter of Shumi Chaudhary within bracket Supra is being passed herein. Stop. The respondent authorities are directed to release the house rent allowance benefit to the petitioner together with all arrears at the earliest, but positively within a period of 16 weeks from the date of communication of this order.
Without applying the impugned memo, that was the observation of the. Without applying the.
Court's order is there, what they will apply?
They will be saying that court has not, this court has not said. She knows the view, otherwise.
Is there any rejection in your case? There is no rejection.
No, that particular memo, stop my payment. My payment has been stopped.
Right, but then no, there is no.
No formal order is there. But that particular circular will not apply to me, so otherwise they will not give it. Excluding the impugned memo.
Restricting a grant of house rent allowance to the teachers whose spouse receive house rent allowance from the employer.
Private employer.
Of a private organization will not be made applicable in the instant case. This post service taken on record.
My lord, I'm for the petitioner, but I'm being led by Mr. Nikhil Gupta. He's appearing virtually, man.
My lord, in this item number 8 and 9, my lord, it relates to 2016 SLST matter, my lord. And your lord, my lord.
All right, then it has become infructuous.
My lord.
The matter relates to the recruitment process of SLST 2016. Stop. The entire selection
No, no,
process.
this is not one of those matters.
He says so.
No, this is an upper primary 2016 matter, not, yes.
Yes, Mr. Nikhil Gupta.
My lord, this is upper primary, my lord. 2016.
All right, then what you want? Appointment letter?
My lord, I am a qualified candidate, my lord, but no appointment letter has been
ঠিক
issued.
আছে আচ্ছা তাহলে এটা ওই এর আগে একটা বললাম না
My lord, it is same as item number 6, my lord, where
Yes, right.
Mr.
Six.
Anjan Bhattacharya was appearing, my lord.
Item 6. All right, 9 also.
8 and 9, my lord.
My lord, the affidavit of service be kept on.
Yes, please.
Extremely grateful, my lord.
Same, 8 9 same. Affidavit of services.
Dismissed.
Grateful, your lordship.
Deeply obliged.
মানে পাসওয়ার্ড দিয়েছে সময় দিল না কিছুতেই
সময় দিলে তুই বলেছিস মা হাসপাতালে না সেটা তো বলিসনি তাই
বলিসনি
আমি বেরিয়ে যাবো
Lordship, Robiul Islam is appearing in this matter on behalf of the petitioner, Lordship. The thing happened, actually, we overlooked the previous order, Lordship, that says to serve upon the school authority. So kindly grant us some time, Lordship, to serve and come back.
It is nearly 2 years. Who are you representing?
I'm for secondary board.
Mr. Shamimul Bari appear for the state.
But my lord, notice not served, my lord.
Lordship, we overlooked it. Kindly, Lordship, grant us some time to serve and come back.
What is the issue over here?
Well, here the petitioner was absent for more than 5 years, near 6 years, due to the reason is because his wife was not well. And thereafter his wife expired, and thereafter he wants to, I am not sure whether expired or not, but he wants to join back. But this but he was not allowed to join. That is the issue of it. Because 5 years, expiry of 5 years, that deemed resignation come. But well, that is what I remember. I don't have the brief because, your lordship, at late night I have seen the matter has come up without notice, my lord. I could not trace out the brief.
Accommodation has been sought for by the learned advocate representing the petitioner. Stop. It appears that direction was passed by the court on 1st April 2024 for service of notice upon the school. Stop. The same has not been done. Stop. Let further notice be issued to the school authority. Stop. Release the matter on 29th of January 2026. Stop. Learned advocate appearing for the respondents shall come ready with all necessary instruction on the adjourned date.
Lordship, much obliged, Lordship.
Give your name only. Only your name.
Okay.
This is a gratuity interest, my lord.
Interest on gratuity. When was it disbursed in your favor?
Superannuation on
I'm for
30th
the state, my
June
lord.
2019. Pension payment order 9th March 2022. Payment was made April 22. Gratuity amount 3 lakhs.
Interest on gratuity, usual order. Next. Disposed.
Item number 12, I have on behalf of the petitioner, my lord. I want a accommodation because, my lord, notice not been served, my lord. Comment to the government.
2023 writ petition notice has not been served.
No, my lord. Upgradation notice not been served.
Why? Why did you mention for upgradation if
My lord,
without any notice?
My lord, kindly one day accommodation.
Disposed of.
Area salary had been paid, but interest not been paid. Right. During the lifetime of the writ petitioner, area salary had been paid, But
When did the petitioner retire from service?
my lord,
2012.
my lord, all pensionary benefit has been,
Released in 2017,
yes, my lord.
right? And you filed the writ petition in 2023.
My lord.
Why? Why?
Actually, my senior
Who is your senior?
Ashwini Kumar Bera, my lord.
Where is he?
My lord, code number
Call him.
551.
Call him immediately.
My lord.
Yes, next.
My lord, I am appearing for the. My lord, I am appearing for the school. No notice was served upon us prior to upgrading.
It is intimated, my lord.
How?
Yesterday night, I have to take instruction of the school.
But the writ petition of 23, you didn't take instruction in the meantime.
Coming up after a long interval.
What? What is the matter?
Only, my lord, the scale of pay given from the date of approval. Is the DA getting in school, my lord? And all the similarly placed other teachers are given from the date of appointment.
All right.
And there is another order from of the division bench, my lord, from the date of fitment.
Date of fitment.
She was engaged on a sanctioned vacant post on the post of another teacher who retired 1 year after of her.
Where is the request before the authority?
Pardon?
Where is the request before the authority?
There is several requests.
Show me one.
Mr. Body is leading me, my lord.
Show me one.
There is several representations, my lord. And it comes
Page 90, there is a
61.
1 minute. Page 90, I can see a hearing was conducted. Where is the reasoned order? Where is the reasoned order?
Page 74, my lord. 80. Some amount was credited to his account from the date of his approval. Her approval. And
Page 90. Come to the writ petition, page 90. You filed a writ petition earlier.
My lord, my lord.
And pursuant to the order passed, a hearing was called on 5th of April 2024. 23. Where is the outcome of this hearing? Who's for the state?
My lord, I am for the state, my lord. This part, my lord, I have to, my lord, check my that
This is the only part.
only part.
And
Others are earlier this contempt
earlier gone.
that has been
I can see page 90, 23.
only 90, my
A
lord.
hearing was conducted.
And
Well,
there
I was-
typed another representation, my lord. Page 91. Onward, my lord. My written submission, my lord. Thereafter, no order has been passed.
Please come. The petitioner seeks higher scale of pay on and from the date of his appointment. Not his, but her. Appointment.
Fitment.
Yes.
And kindly, one thing, my lord.
It appears that the issue was taken up for consideration by the District Inspector of Schools, Secondary Education, Kolkata. And a hearing in terms of the order passed by the court in WPA 93 of 2021 was scheduled on 5th April 2023. Stop. The fate of the hearing has not been made known to the petitioner. Stop. Without entering into the merit of the claim of the petitioner, as it appears that the issue was already taken up for consideration by the District Inspector of Schools, accordingly, the authority ought to have passed a final order in the matter. Stop paragraph. Nearly 3 years have elapsed from the date of the previous order passed by the court on 22nd February 2023. Stuff. Next. In view of the above, the where is 22nd February 23's order?
Page 84.
ওই ইয়েতে ডিআইপি হিয়ারিং ও কবে দিয়েছিল এটা 23 এই হ্যাঁ
আচ্ছা।
24 সাল
In view of the order, now in view of the above, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Kolkata, to take steps strictly in accordance with the direction passed by the court on 22nd February 2023 in WPO number 93 of 2021. ঠিক আছে? Final order shall be passed by the authority positively within a period of 8 weeks from the date of communication of this order.
Last order on 24th December 2019.
23 তে হলো।
না, ওটা তো আগের আরেকটা মামলা।
That has been complied. 2019 order has been complied.
That has been complied.
Disposed.
I am grateful, ma'am.
Everyone.
14, I am for the
Service আগের মামলায়। আগের মামলা service.
14.
Anybody who is not present, Shubroto Babu, anybody who is not present, name will not be recorded. Yes, please.
14, I am for the
No, I'm for the state response.
that the lawsuit will find page 30, page 27, petitioner initially was an assistant teacher. From assistant teacher, he joined as assistant headmaster. Page 27. Since the school was a higher secondary school, page 28, as per this government order, at the bottom, assistant headmaster, serial number Roman 2. Assistant headmaster, assistant headmistress, right hand side, 2 additional increment in the revised pay of Rupa 98. This is the fixation of assistant headmaster in higher secondary school. The lawsuit will find page 30. DI has approved my pay scale, page 30. The 30 fixation, middle portion, less 1 increment as assistant teacher, which I was enjoying. Thereafter, 2 additional increment was added. You will also page 30.
302 additional increment allowed.
Previously, the less 1
increment.
Less 1 increment 250. Then 2 additional increment. This was done by the DI. The next page, page 31. After ROPA 2009, DI had fixed my pay scale. On the basis of the pay fixation, I was enjoying till my retirement. My last pay was, you also will find my page 48, 92,000, page 48. This is the pension application was submitted to the DI. I retired on 20th February 2021, and last fixation 1st July 2020, 92,000. This has been reduced, on the basis of objection raised by the, you also will find my PPO. I now am receiving pension, page 57. That is lawsuit 89,300. Last pay, you also will find just after 4 lines. Pension payment order. Only I am paying he made a representation for the fixation of pension. Page 59. Regarding fixation, I am not paying any mandatory order. Page 59, you will also direct the Commissioner of School Education, because the objection comes from DI. That should be considered, and to take a decision. Because
When did you make the representation?
Make the representation. That is after retirement, page
23.
2023, page 61.
But then page 65, I can see you approached this court earlier.
Page 50 cases, that is my lord the regarding overdrawn, only my lord the challan, by challan my lord the I refund the amount. I moved a petition and my lord the only this honorable court directed to refund in view of the Rafi Masida. But regarding refixation, he made a representation.
Page.
Page my lord 60.
Please come. What is the submission?
Yes, my lord.
What? Yes,
Let,
my lord.
my lord, this representation is required to be considered.
Also, the petitioner is a retired school teacher. Stop. He received. Now, he retired from service on 28th February 2021. And as per the pay statement, his last pay drawn was 92,000 per month. Stop. At the time of issuance of PPO, the last pay drawn was shown as 89,300. Stop. Certain sum was deducted from the PPO of the petitioner on account of overdrawn payment. Stop. The petitioner approached the court seeking refund of the deducted amount by filing writ petition being WPA 4027 of 2023, which stood disposed of in favor of the petitioner with the order dated 5th July 2023. Stop. The petitioner has made representation before the authority seeking refixation of his pay scale. Stop. It has been submitted that the scale of the petitioner ought not to have been reduced after his superannuation. Stop. Paragraph.
Since the representation addressed to the DPPG and DI, so kindly my lord,
I'll give you leave
to make a comprehensive representation to the
আচ্ছা ঠিক আছে from the documents annexed to the writ petition, it appears that the same has not been served upon the Commissioner of School Education. Stop. As the pension sanctioning authority of the petitioner was the District Inspector of Schools, and the amount and the last pay drawn appears to have been reduced upon the instruction of the District Inspector of Schools. Accordingly, the court thinks it fit to dispose of the instant writ petition with the observation that it will be open for the petitioner to make comprehensive representation before the Commissioner of School Education, annexing all documents in support of his stand. Stop. In the event such a representation is made, the same shall be considered by the Commissioner of School Education strictly in accordance with law after giving reasonable opportunity of hearing to the petitioner and the representative of the District Inspector of Schools, and thereafter pass a final order in the matter. Stop. A decision shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
In the event my lord, the commissioner comes to in my favor.
If the prayer of the petitioner is accepted by the Commissioner of School Education, then necessary consequential steps shall be taken without any further delay. Dispose service on record.
Grateful.
My lord, I'm praying for one indulgence lordship with lordship full and also item number 4. I was stuck in Lordship, court room number 11, Lordship. It was most likely dismissed for
The court is in the midst of the list. Please do not disturb.
Lordship.
Okay, for the petitioner, my lord, led by Mr. Shubhi Sharad, our senior advocate. For the petitioner, my lord, he is a student, and
Where is the notice upon the other side?
notice has not been served.
Notice has not been.
Yesterday,
No,
first
your
evening,
notice not
received
served.
a notice. In fact, Lord will kindly see.
Let
May I
me hear
place
the
the case?
petitioner.
May I place my case, my lord? The petitioner student, my lord, he is agreed by the marks obtained by him in the CBSE board examinations of class 12. That was held in 2021 during the pandemic period, my lord. So the board examinations were in fact cancelled, and a certain modalities were prescribed by the board regarding computation of marks. That is at page 26. This is the notification issued by the board of 17th of June 2021.
Yes.
My lord, may straight away come to clause 4, procedure for assessment of students at page 28.
Yes.
In class 12 examination, bifurcation of marks in theory and practical or internal assessment in various subjects is as follows. My lord, in short, each subject is 100 marks, practical 80, 20, 70, 30, whatever is the subject. My lord, then comes to clause 6. This is main 6A. Due to cancellation of the board examinations, the assessment of theory portion of such and such marks will be done by the school based on the following. Class 12, marks based on unit test or midterm or pre-board examination, 40% is a weightage. Class 11, marks based on theory component of final examination, 30% weightage. And class 10, marks based on average theory component of best 3 performing subjects out of main 5 subjects, 30% weightage. Then, my lord, clause B, the marks of practical will be on actual basis as uploaded by the school on the CBSE portal. So practical examinations were already complete, held individually by the schools. So whatever marks were awarded by the schools, that were to be finally incorporated in the final result. Now, my lord, the dispute arose regarding theory. My lord, if I go from class 11 to 12, sorry, 10 to 12, class 10, it says marks based on average theory component of best of 3. 5 main subjects, we will take 3 best of those and we will compute the average. My lord, will come to my mark sheet, class 10 mark sheet of my class 10 at page 43. My lord, class 10, my lord, total is 100 marks in each subject, except computer applications where the total marks is 200. Now, my lord, will find from the statement of marks, there is no division of the theory and practical marks. Total marks, suppose one in English language, total marks at the top says max marks 100, marks obtained is 75, 98. So percentage is given 87 in English.
Are you there in page 43?
43, my lord. Statement of marks.
Yes, statement of marks.
My lord, will find in each subject, total marks is 100.
Yes.
And the marks obtained,
Right.
English language 75, literature 98. But the division is not given, theory and practical. My lord, theory was 80, practical is 20.
Even in
Even if
English
we
language, there is practical.
My lord, in all subjects there is practical.
All right.
But even if we assume that 20 marks in practical, so we keep deducting all the 20 marks from each of these marks, then my lord, we will find the theory marks, because we need only the theory marks for our computation in class 12 board examinations. So when I suppose in English language 75, if we deduct 20, 55. So this time, my lord, I have prepared a chart.
No, but then in 98, literature in English 98, how can you deduct 20 if the full marks is 100?
20 I'm only saying in 80. Out of 80, if I deduct 20, 20 is practical. Now this is
Right.
100.
This is
So-
100.
Yes.
So you say in language you got 75.
Yes.
It has to be taken that it is in
both.
On
This is both theory and practical. Total is
Both.
100.
All
So
right.
if we divide 20 and 80 and we take off 20 out of 75 is out of 55 means out of 80 I get 55. And here 98 means, but we are assuming that 20 marks I have got in practical. My lord, worst case, I have got not 20, 18. So my theory will increase automatically. So my case gets better, all the more.
No, what is your case? I do not know as
My
of
lord,
now.
coming to that. My lord, my numbers have been drastically reduced. My lord, there is no scope of any assumption over here. Only except this, my lord. This is also board. So board better knows what marks I have obtained in my theory and practical marks. Now it's my assumption. If I take 20 marks, deduct. So even in literature and English, 98 comes to 78. That is out of 80 marks. Theory. Now only concerned with theory, my lord, because practical they are not doing anything. Only theory. Now what my marks will come to, that I have prepared a chart going by their own policy, how much I ought to have obtained in class 10 theory. That is at page 9, my lord. No, 9, page 8. No, sorry, page 8, my lord. Paragraph 12. So, my lord, by doing that calculation, my best of 3 average comes to 23.5. My lord, there cannot be any dispute with regard to my theory marks. It is in the hands of the board. They are the best person to tell us what is. Next, Kamal, this is class 10. This way, my lord, we are taking best of 3 subjects and we are doing the average as required by their own notification. And that calculation comes to 23.5. That calculation I have given at paragraph 8. Paragraph 8,
So
I have given
what are you driving at?
My lord, my point is everything is based on theory.
All right.
Only a weightage, 40%, 30%, class 11, class 12, whatever marks is given, they have to give the weightage. So there is no assumption.
Yes.
Now, my lord, whatever the mark sheet that I have received, that marks has been drastically reduced. Well, suppose in a particular subject, I was supposed to get 85 on the basis of this calculation, it's 65. Mala kindly sees the mark sheet issued by the board. At page
47.
47. English core. Theory is only 60.
Page 43 is your marks.
Of class 10, my lord.
And this is
47 is the 12. Senior School Certificate Examination
All right,
2020.
12. 21, this is 19.
My lord, I have prepared a chart of what is the difference in the marks. That is at page 15, paragraph 27.
All right.
In mathematics, my lord, difference in marks 26. Physics 23, chemistry 16, computer science is 15, physical education 19. How come this much difference is unbelievable? Everything is based on computation of marks. But the result is that my percentage comes to 68%, whereas I ought to have got more than 80%. Now, why I am suffering, my lord? Right now, my lord, I have completed my BTech course from Vellore Institute of Technology. Now, I cannot get admission, rather job offers in prestigious companies because every company is asking for 80% minimum. Now, I have got only 68%, at least 70% they require. Because of 68%, these marks, I cannot apply for any job. This is my difficulty.
This came to your mind after your
lord.
claim for appointment of job get rejected.
No.
This is a 2021
21, my,
examination.
2021, my lord, I immediately got admitted to Vellore. I have explained, my lord, why the delay. Vellore Institute got admission, and immediate upon admission, my lord, there were 5 semesters back to back. I could not, my lord, take up my mind and get into this court cases. Only when in August 2023 there was a gap for internship purpose. Only that time, my lord, I took. My lord, I made a representation before the principal as per their policy.
After
That was
2
also,
years, Lordship.
that was also kept pending. No, within time.
After
That
2
was
years, Lordship.
That was
Are you
within
there
time.
for the board?
I am appearing for the school. She is submitting that they have made representation before the principal. Lordship, they have applied in prescribed format for the dispute on 9th August 2021. And the representation was made after 2 years, Lordship. That is on 6th September
Prescribed format is what is to be
2023.
done. Prescribed format was done in time. They are waiting for when I will make the representation.
And they have filed this writ petition in the
That is
December
in
2023.
My lord, during COVID, the board could not hold the examination in usual manner. Now, a policy was, my lord, adopted, and modalities were prescribed. How to, my lord, evaluate, tabulate the marks. Now, they, my lord, my learned friend was showing the first circular, that is 26. Thereafter, a subsequent circular was issued on 8 August 2048.
Page 48.
There, my lord, this was 8 August 2021, and this was the year when the student sat in the exam. Now, the procedure was types of dispute covered. What are the disputes? What are the types? All these things were prescribed. Now, thereafter, kindly come to next page, modalities to address the dispute, and modalities to address dispute number 3. Different disputes were there defined. Now, under the my lord, policy, my lord, a committee had been constituted in each school. 5 members, 4 members from the subjects teacher and 1 principal. And principal was now they were to, my lord, look into the dispute. What are the dispute? Now, if there are certain dispute which were required to be sent to the board for adjudication as per this policy. Now, this policy was, my lord, approved by the Honorable Supreme Court also. As per that, my lord, this policy, because that time we could not hold the exam, there was a confusion. And now, as per that, my lord, this was said. Now, to 21, this was said. Board did not receive any specific request. But because there was a portal, SOS Shiksha portal or something, it was to be, my lord, they were required to, my lord, upload. And board, whatever disputes received by the board has looked into it and resolved the issues. There is no reason. Now, kindly see, as my learned friend pointed out, the result was published in the year 2021. Kindly see at page 47. And the writ petition was filed in the year 2024. Now, what is the grievance? Now, kindly, Your Lordship kindly comes to their letter. The reason being, at page 53, this is the only letter they have. Before that, my lord, this was in 23.
No, my lord.
Now,
23.
Kindly comes, Your Lordship kindly take, they have discussed, kindly, Your Lordship kindly comes to page 56. This is the reason why they are asking for, they have filed the writ petition and now they are seeking orders. Now, my lord, it happened 21 and
24.
At page 56, last para. It is noteworthy that currently I am pursuing BTech in Computer Science in Vellore Institute of Technology. The classes are Vellore, commenced from 13 September 21. And prior thereto, I had to appear in several entrance examinations that were being conducted by the different universities and colleges, my undergraduate course. After joining Vellore Institute of Technology, I had to appear in 5 semester examinations without any break in between, except occasional breaks of about 2 weeks only. After back-to-back 5 semesters, finally there has been break of 5 months from 1st August 23, so as to allow us to undergo internship in different companies. Such being the situation in the interregnum period, it was not possible for me to take any further steps with regard to the aforesaid application dated 9th August 21. This is it. Then be it mentioned that all major reputed companies have a minimum requirement of 70% marks in class 12 to be eligible for internship in such companies. Having obtained 68% in class 12, for no fault of mine, I am being deprived of these opportunities. Under the circumstances, I request you to kindly take up the matter with the controller of the so. Now, my lord, we did not receive any, my lord, complaint at the relevant point of time. We could not. Had we received any complaint, my client has instructed me, only there were mass, my lord, representation from 101 students from the school in 2021. Now that was looked into, and whatever complaints were required to be looked into, we have done it. Now result was
What is page 52?
52.
Applied for the dispute.
Yes, she had applied for
Clearing the dispute.
raising the dispute. No date.
No date.
No date.
Was it at all uploaded in the portal or anything of that sort?
According
There
to
is
this was not uploaded. No. This is a specific instruction I have received. Instruction, my lord, written instruction. They have said, my lord, I'll just only one instruction. Here in the instruct case, the school had raised mass representation of 100 students, 101 students without any proper verification record by not specifying any error in computation as per guidelines of policy. It was simply stated that the students and parents are agitated and not satisfied with the result. This was the only thing. There was only one mass representation. In fact, my lord, if your lordship kindly takes that 8th of August 21 circular, there was a lord, procedure prescribed.
My lord, page 52 is a representation that I was supposed to make in terms of their own policy. My lord, their policy, my lord, kindly comes to page 48. Clause 1, my lord, types of disputes or cases covered. What are type 1 and type 2 disputes? Disputes regarding computation of results. Next paragraph, below, the result committee has prepared the result and uploaded on the website of CBSE for its computation. In case candidates feel that they are not satisfied with their marks awarded, they can make representation to the principal of the school for verification and reply by the school to the candidate concerned. My lord, next page, my lord, page 50. That is clause 6, schedule of activities, type 1.
This is important.
Start date 9th of August, end date 11th of August. My lord, page 52, that's not written, my lord. My specific averment at page 11, paragraph 17. Petitioner made an application before respondent number 6, that is the principal, far back on 9th of August 2021 in terms of the circular dated 8th of August. Praying for revision, however, till date, petitioner has not received any reply, nor has his result been updated till date. 52, my lord, as per their own policy, within time of 9th of August, I made to the principal. I waited, no reply received. It was only then this page 53 representation was made. They are only relying on the representation, not on this, as per their own policy, what we have made. My lord, delay, my lord, already explained, my lord, I'm a student, my lord.
Very well,
It's
please
not
come.
possible for me to go up behind this in court cases.
The petitioner appeared in the Senior School Certificate Examination, 2021, conducted by the Central Board of Secondary Education. Step. He is aggrieved by the marks awarded to him. Step. Paragraph. As the subject examination fell during the COVID period, the Central Board of Secondary Education published a circular on 8th August 2021 as per the direction given by the Honorable Supreme Court, prescribing the policy for tabulation of marks and the manner in which the disputes of the students are to be resolved. Stop. The petitioner contends that that objection was raised within the due date before the school authority in terms of the aforesaid circular in September 2021, but the petitioner has not been intimated the fate of the said objection. Stop. A written representation was made to the school on 6 September 2023, but there has been no response to the same till date. Stop. The petitioner has disclosed in the representation filed before the school that though the result of the board examination was declared আচ্ছা একটা জায়গাতে বললাম না যে September 21 he made representation. First representation was made on August 9th August 2021. পরেরটা হচ্ছে 6th September 2023. ঠিক আছে তারপর কি বলছি was declared in July 2021 and he made the objection before the school in August 2021 in terms of the circular dated 8th August 2021. But as he was pursuing BTech course at Vellore Institute of Technology and he had to appear in several entrance examinations conducted by different universities and/or colleges for admission in the undergraduate course. Accordingly, he could not ventilate his grievance before the either before the board or before this court prior to 2023 when he got a break of about 2 weeks. Stop. The petitioner submits that he got very high marks in the class 10 board examination, but his marks in the class 12 board examination got substantially reduced. Stop. Because of illegal reduction of marks in the class 12 level, the petitioner is losing his opportunity to get appointment in good companies. Stop. The prayer has been made to revise the marks of the petitioner awarded in the class 12 board examination and to issue fresh mark sheet. Mentioning the revised marks. Stop. The submission and prayer of the petitioner is opposed by the learned advocate representing the board and the school. Stop. It has been submitted that the examination was conducted way back in 2021, but the petitioner has approached the court in the year 2024. Stop. Learned advocate for the board refers to the modalities set out in the circular dated 8th August 2021 for redressal of the disputes raised by the candidates. Stop. It appears that the board set up a within quotes school request submission for resolution system where the disputes were to be uploaded. Stop. A committee was constituted for resolution of the disputes. Stop. The circular prescribed specific timelines within which the disputes were to be resolved. Stop. It appears therefrom that the entire process of resolution of the dispute ended in August 2021. Stop. Paragraph. The petitioner, though claims that an application was made through the school within the time schedule disclosed by the board, comma, but the learned advocate representing the board submits upon specific instruction that the mass request made by the principal of the school was duly considered and disposed of. Stop. There was no request for or on behalf of the present petitioner. Right?
We did not receive a specific complaint. This was not received.
Acha.
So
The specific complaint allegedly made by the petitioner annexed to the writ petition at page 52 was not received by the board.
and no date. That kind.
Stop.
It does not bear.
The subject objection at page 52 is an undated one, and there is no proof that the said representation was either submitted before the school or the board. Stop. Next. Upon hearing the submissions made on behalf of both the parties and on perusal of the materials before this court, it appears that, admittedly, the result of the subject examination stood declared in July 2021. Stop. 2021, stop now. During the COVID period. Stop. The board claims to have acted in terms of the circular which was issued on 8th August 2021 in compliance of the directions passed by the Honorable Supreme Court. Stop. The dispute redressal committee set up by the board has been dissolved in terms dissolved on the date as prescribed in the subject circular. Stop. Though the petitioner claims that objection was filed within the prescribed date, comma, but it appears that the petitioner was not vigilant enough to proceed with his objection. Stop. He proceeded with his studies in the graduation level. Stop. Only after expiry of more than 2.5 years after publication of the board result, comma, the petitioner filed the instant writ petition on 4th January 2024, claiming relief against the board by praying for issuance of fresh mark sheet upon revision of the marks awarded to him. Stop. Paragraph. The court is of the opinion that the explanation provided by the petitioner for the delay in approaching the court cannot be accepted in the facts and circumstances of the instant case. Stop. The board cannot be mechanically directed to revise the marks of the petitioner. Stop. The committee, which was set up for the particular purpose, is no longer available. Stop. The circular and the guidelines and modalities published by the board are no longer in force. Stop. Paragraph. Had the petitioner been genuinely aggrieved by the marks awarded to him, he ought to have rushed to either to the authority or to the court within the shortest time possible. Stop. Paragraph. The same has not been done. Stop. The court is not inclined to interfere in the instant writ petition. Stop. The writ petition fails and is hereby dismissed.
Right.
The entitlement is not disputed, madam. Only.
I'm state respondent.
Petitioner? Yes.
But it's a very long pending case, and there are several writ petitions have been moved before the High Court, and there are several orders, including his transfer, suspensions, allowances, and subsequently.
What is your prayer in the instant writ petition?
He has been retired. Subsequently, he has been retired. Now, I claim for any retirement benefit without any due process of law, whether I am entitled to any retirement benefit or not. There is no departmental proceedings due to unauthorized absence, due to my medical ground. And now, at this stage, my lord, I claim.
When did you retire?
No.
2023.
23. All right.
That is when this petition was moved.
16th. Any, भूल है 31st July 23.
How many years did you serve?
My lord, according to he was initially appointed on compassion ground. Due to die,
Group D staff.
His father as a group D staff.
When were you appointed?
2016. 2006.
When?
My lord, it is appointment letter is there.
Initially.
Yes, by the 4/5/2006. 4th
All right.
May. 4th May.
Yes.
Thereafter, he was continuing his service. Subsequently, he met this accident in 2013.
All right.
And thereafter, he totally absent from his
without cause.
from the school.
Right. So from 2006 to 2013, you served.
Yes. Thereafter,
you could not join.
He made an application for transfer, general transfer, with no objection certificate from the school authorities, but that was not granted. Subsequently, he filed a writ petition before the High Court, and High Court directed to give him no objection certificate, and that no objection certificate was subsequently not given. But in the meantime, he was again moved during suspension period to give a suspension allowances. That was also not allowed. Subsequently, order was passed by the High Court that yes, he is entitled to get a subsistence allowance, and that order was passed by the High Court, and that order was subsequently recommended by the DIF schools at page, my lord, kindly. It's
page 43. 81. 81.
পেয়ে গেছি
My lord, that is 81A, my lord, page. Yes, 81A, my lord. Page 81A. Additional District Inspector Schools. Boni Amin, Group D staff was absent from Atu to Atu. The school authority suspended with effect from 2015. Suspended in 2015 by meeting number such and such. The school authority also asked the Boni Amin for giving his reply in the suspension letter dated such and such, but the school authority did not get any reply from his end. proposal for approval of suspension of was disapproved by the West Bengal ESC and 2016, which was communicated by officer number such and such, was requested to send a fresh show cause notice to Boniam. As per decision of the said hearing such and such, the authority issued show cause notice to Boniam to reply within 7 days from the date of receipt of the letter by dated the school, but the school authority did not get any reply from his there. As per produced copy of the service book, attendance register, it appears Boni Amin was absent from 10/12/2013 to 4/10.
So you practically served from 4th May 2006 till October 2013.
Yes.
How are you entitled to get your terminal dues?
According to my lord, thereafter suspension order has been revoked by the High Court. That order is also there.
Page 82 to
This is Sarafir order. This is Saraf. This is Sarafir order.
No. Order.
This is Sarafir order.
You should have been prepared. You cannot waste such a lot of time.
Almost petition.
Sorry, my lord.
Come ready. It cannot be done in this manner.
Yes, my lord. There is so many orders there.
Not today. Nothing doing. Call the next matter, please.
This is Sarafir order.
Lord, I am for the petition in this matter.
Lordship, I am for the secondary board.
My Lord, I have a very limited prayer before your Lordship today. My Lord, the petitioner belongs to the Calcutta, the two authorities. Petitioner are the assistant teachers of Calcutta Airport English High School, which is located at the land of the Calcutta Airport. Well, this is an integrated school, primary, secondary, high secondary. It's a private school, but the management is run by the board, West Bengal Board of Secondary Education, because it is under the ad hoc committee of the board. Presently, previously it was under the administrator appointed by the board. Now, my lord, my only grievance is that, my lord, I was appointed nearly 23 years back. My lord, I was given the pay scale in terms of ROPA. Until ROPA 98, I received. Since ROPA 2009 and 19 came up subsequently, our pay scale has been reduced, which is not permissible, even below the 98 ROPA which we used to get. Now, my lord, we made several representations before the board, my lord. Let my representation be considered at page 83. That is my humble prayer, because it is to be computed.
Last occasion, Lordship, 14th May 2024, coordinate bench was directed to serve fresh copy of the school authority, Lordship. Lordship, school is the
No, the ad hoc committee.
Honorable
Yes.
Justice.
My lord, this ad hoc committee has got
14th
changed.
May
That is under the
2024,
board
Lordship,
itself.
but school did not.
No, it is a board appointed ad hoc committee. So board before the president
Lordship.
school, there is no managing committee.
The petitioners.
My lord, I have prayed also to the
Seek
area
pay protection.
along with area, my lord.
A representation by the petitioners is pending consideration before the West Bengal Board of Secondary Education. Stop. Without entering into the merit of the same, the instant writ petition stands disposed of, directing the board to consider the prayer
My
of
lord,
the
I have a
petitioners
DI instruction of DI.
strictly in accordance with law at the earliest, after giving reasonable opportunity of hearing to all the necessary parties.
My lord. আমাকে একটা কপি আছে না দিয়েছি
আচ্ছা, ঠিক আছে। A reasoned order shall be passed and communicated to the parties. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Instruction forwarded by the District Inspector of Schools, Primary Education, North 24 Parganas, dated 10th May 2024, is taken on record. Character line. Leave is granted to the petitioners to forward all documents in support of their claim to the aforesaid respondent at the time of communicating the order of
My lord, pay fixation along with area and interest. Kindly mention that. Otherwise, they will say that
whatever is there in your
no,
representation.
your lordship has recorded pay fixation. They will say that you have not mentioned.
Pay protection,
Pay
not
protection is including
fixation.
area and interest. My lord, I have made clear.
Pay protection. If you are entitled to the protection, you'll get everything.
Yeah, very well. We have been facing this problem since 23 years. That is why I'm a bit apprehensive, my lords.
Deeply
Grateful to
organized.
your lordship. My lord has directed for a hearing also to be called as yes. Grateful.
I beg to appear before your lordship through your virtual mode, my lord.
Yes.
Can you
Lord, I
allow?
am appearing on behalf of state in this matter.
At the very outset, my lord, I must submit before your lordship the intimation upon the concerned the advocate of the concerned respondents was given only on yesterday, my lord, evening. As my lord, I was not well to move this matter remaining physical present before your lordship. If your lordship kindly permit me to move this matter through virtual mode, my lord.
Yes, certainly.
My lord, I shall place the prayer portion before your lordship to cut the matter. This is there is a checkered history in this matter, my lord. Your lordship kindly have a look to page 40, the prayer portion.
Yes.
My lord, your lordship will find, my lord, President, Board of Secondary Education, Respondent number 3. I have prayed from giving any effect or further effect to the purported order dated 10th August 2023, passed by the President Ad hoc Committee, West Bengal Board of Secondary Education, as it appears. The letter of communication dated 12th September 2023, issued by the Deputy Secretary General, West Bengal Board of Secondary Education, containing the order passed by the President Ad hoc Committee of the Board dated 10th August 2023, without annexing any copy of the same, along with the purported letter of communication dated 12 September 2023, wherein it was declared that Srimati Shukla Pandya Rajak, assistant teacher in history of Ghospur Sri Nehru School, High School, Post Office, Ghospur under Keshpur Police Station, is deemed to have been resigned with effect from 22nd December 2012 and accordingly ceased to be in employment of the said school, creating the vacancy of the post with effect from 22nd December 2012, as he remained absent for more than 5 years from the school in accordance with Rule 11, Sub-Rule 1 of the board's leave rules. But the second prayer was more particularly President West Bengal Board of Secondary Education, Respondent number 3, to supply the purported order passed on 10th August 2023 in compliance with the order passed by the Honorable High Court on 26 June 2023 in WPCRC 118 of 2023 in WPA 10425 of 2001, 20, that would be 2021. As the impugned order passed on 26 June 2023 is not in existence now, which was clarified by the Honorable Division Bench in MAT number 2023 with CAN 01 of and CAN 2 of 2023 passed on 11th October 2023, holding paragraph 10 of the order shall not be considered to be a finding of the learned single judge with regard to the claim of the writ petitioner, either for employment or condonation of absence or any other right as directed under the paragraph 15 of the impugned order. Next, my lord, prayer was President West Bengal Board of Secondary Education, Respondent number 3, District.
No, it is all right. Your prayer has been couched in such a manner that the entire writ petition is there in the prayer. Right?
Yes.
No, so you are aggrieved by the deemed resignation.
Yes.
My lord.
What is your submission?
Last minutes.
But only letter of communication was there, but no order passed by the President, my lord. That was not served with the copy of the communication letter. That was not given, my lord. While, my lord, the appeal against the order passed by the Honorable Justice, my lord, Rajasekhar Mathai, the contempt jurisdiction, my lord, that was under challenge for the Honorable Division Bench. The Honorable Division Bench held that that was not the observation of the learned court in a contempt proceeding. That was the submission of the learned advocate on behalf of the board, my lord. That was So, the decision taken by the president, that was not served upon me first of all. Secondly, the order passed by the honorable judge is not in existence as per the order passed by the division bench. Your lordship kindly have a look to the order passed by the honorable justice Rajasekhar Manta in contempt proceeding, my lord.
On 26th of June 23.
Yes, 253, page 253.
Yes.
My lord, your lordship kindly have a look to the order passed by the honorable justice Rajasekhar Manta, page 253. Your lordship kindly have a look to 253. May I read that, my lord? In a contempt proceeding, page 253, your lordship kindly have a look to.
Yes.
This court finds both the president of the West Bengal Board of Secondary Education and the headmaster of the school equally irresponsible. The teacher in question was absent for more than 11 years from the school. A plain reading of Rule 11(1) of the Leave Rules of the West Bengal Board of Secondary Education would indicate that a teacher absent for a continuous period of 5 years is deemed to have resigned from the service unless the headmaster of the school recommends any special reason to the board to treat the absence of the teacher and condone the same. The headmaster and the president of the West Bengal Board of Secondary Education have been passing the buck between each other by reference to Rule 11(1) of the Leave Rules of the West Bengal Board of Secondary Education. Issue has been stuck in red tape as a consequence of the sheer carelessness of the president of the board and the headmaster of the headmaster. The students have suffered for 11 years. The school has explained the management's stand but has chosen not to make any recommendation as to whether they want the teacher to serve in the school and whether the board should condone or consider condonation of 11 years of absence. President of the board has behaved in a pathetically bureaucratic manner despite letters from the headmaster. He ought to have explained and sought specific instruction from the headmaster. M.S. Bhattacharya, learned counsel appearing for the board, submits that there ought to have been resolution from the managing committee of the board school. In the above process, the students of the school have been deprived of teacher for next page, your lordship kindly.
Paragraph number 10 of the said order, the court has already
Yes, dear
decided.
lordship. Yes, paragraph 10, teacher Sugla Raja Rajak shall be treated as having resigned from the school from the day she absented herself from the school. The headmaster of the school as well as the president of the board.
Yes, it's all right. Then what has happened?
But what is this observation of the Honorable Court, paragraph 10, teacher Sugla Raja Rajak shall be treated as having resigned from the school from the day she absented herself from the school. It was not the observation of the court, it was seemed to be the same. But I prefer an appeal against this order. The Honorable Division Bench will not have a look, your lordship kindly have a look to the next
61
page, page 260, 61 it starts from. I am reading it out, page 261.
6 and 7 of
Your lordship, MIT 1755, there was a delay, that was condoned, Miller. MIT 755 of 2003 can 2. Appeal is arising out of an order dated 26 June 2023, passed in a contempt proceeding.
See, admittedly, you have absented for more than 11 years then and now, maybe what was the date?
No, your lordship kindly have a look. I am coming to that. First, I am placing this, not 11 years, Milord. I was, Milord, made sufferer as I belong to, Milord, scheduled caste community, Milord, and later on, Milord, I was, Milord, became mentally, Milord, imbalanced and was admitted in the hospital and was under treatment from, Milord, January 2013 to 20th October 2020. Thereafter, I was issued fit certificate and applied for joining there. And no proceeding was initiated against me till date. And this was my submission that under what circumstances, due to the school authority, their misbehavior and conduct, failed to such imbalance, mental imbalance for which I was treated under the doctor from here to there. And ultimately, I was admitted in Bangalore.
No, all said and done, what is the relief that you are claiming now?
But I was praying for resuming my duty since 2020. Honorable High Court was moved and Honorable High Court directed the petitioner to submit a representation detailed submission. I have submitted. That was not considered, which compelled me to file contempt application. And
So right now you are aware of page 264. You prefer appeal, whatever you've got to do. Then cannot be done.
Appeal court paragraph 5, your lordship. If we treat this to be a finding of the largest single judge, then it is not permissible to make such.
This is not an appealable order, your lordship, because after the proceeding concluded, if a final order is taken, that is appealable. Well, this is as per rule 11 of the leave rules that a person.
Where is the final order?
This is the final order.
Page
No. Well, this is not the final order. Well, the final order is under challenge before him, my lord. That, my lord, as far as I remember, it was long back or matter. No notice served upon me in the. However, I could grab the brief in the morning, couldn't go through it. But what I find, there was in the order passed by.
My lord, supplemented affidavit is below. I have filed below.
Serve a copy. As per I remember, my lord, I have served. But my lord, long back, I don't remember. Even my lord, if it had not been served, I'll serve it. I'll take an instruction whether served or not. I'll serve upon it.
Please come.
Yes. My lord, one supplementary affidavit, my lord, annex.
Yes, later on, my lord, I was served with a copy of the order passed by the president of the board. Kindly, my lord, accept the supplementary affidavit containing, my lord, the order passed by the DPI, president of the board.
That was his prayer in the supplementary affidavit.
Yes.
Supplementary.
Kindly have a look to the scriptly order. There is nothing. My application is still pending decision, my lord.
The Did you serve a copy of the supplementary upon the respondent?
Yes. My lord, it's my fault. My lord, in the last night, my lord, I have.
So where is the final order? It is 7 and 8 pages. No, 15 and 16.
No, my lord, this is.
Your lordship, kindly have a look to page, my lord. Page 14. Your lordship, kindly have a look to page 14. Starts from page 14. 1-4.
Where is the final order?
This is the letter of communication. Next page, your lordship, kindly have a look to page 15. Page 15. Note.
Reached the petitioner, my lord. This is the note.
Handwritten note, my lord. There is no order as such.
That is why I'm submitting a lordship. I have to take an instruction whether the final order has been submitted to him or her or not. Because there is a final order. This is the note.
Page 15, your lordship, kindly have a page 15 in the final order.
I'll hand over the final order to Mr. Maiti within day after tomorrow.
Let the final order by the board be forthwith handed over to the learned advocate for the petitioner if not served earlier. Released next Thursday.
A matter to appear before the lordship, my lord. Your lordship, kindly consider the prayer of the petitioner. My lord.
Next Thursday, 19.
I'm deeply obliged.
Thank you, I'm for the picture. Interest on gratuity, wala.
Yes, full deeply obliged to your lordship.
I'm dismissing it. Pradeep, some dates. Petitioner retired in the year 2015. PPO 10th May 2016. Writ petition filed in February
My lord,
2024.
my lord, it received my lord 23, my lord, I have received my lord.
What you have received?
My lord, the entire my lord, money, my lord, the pensionary, my lord, the pension, area pension, gratuity, and everything, my lord, I have. My lord,
Your PPO was issued in 2016.
yes, my lord, that was my lord came pending, my lord, due to some my lord deficiency in paper. My lord, that was my lord, my lord, I have mentioned my lord, the 6th November 2013, 23, my lord, I have received.
Where are documents in support of your case?
My lord, I have paragraph 4, my lord, I have.
Paragraph will not show you show that you received the money on such and such date.
Well, yes, well, then my lord kindly urgent for it. I have supplementary evidence. I shall disclose everything.
Why supplementary? In the main writ petition, it is not there. When the order is passed for dismissal, you say you file supplementary.
I have mentioned my lord, when I have received my lord, that I have mentioned.
Where is the documentary evidence? Once PPO is issued, it is taken that the money is disbursed in your favor. Soon thereafter. And from 16 to 23, for want of documents, how could the PPO be issued if the documents were not there?
There was a dispute in between the school and board. My lord, that's why my lord,
that has hardly got anything to do after PPO is issued.
my lord, that's why my lord, I'm seeking leave, my lord, to my lord, the annex my lord, those documents my lord, by supplementary evidence. Kindly, my lord, don't my lord, dismiss, my lord, kindly give liberty to my lord.
Acha, likhun to. The petitioner seeks interest on delayed payment of his terminal dues. Stop. From the PPO annexed to the writ petition, it appears that the petitioner retired from service in July 2015 and PPO was issued in his favor on 10th May 2016. Stop. The instant writ petition has been filed on 26th of February 2024. Stop. The court is minded to dismiss the writ petition on the ground of delay. Step. Learned advocate for the petitioner submits that though the PPO was issued in May 2016, but the money was actually disbursed when?
6th November 2020.
On 6th November 2023. Step. There is no supporting documents in respect of the submission made by the petitioner. Stop. The petitioner, learned advocate for the petitioner seeks leave to file supplementary affidavit. Stop. For ends of justice, let supplementary affidavit be prepared and circulated by 16th January 2026. Release the matter on 21st of January 2026.
Grateful, ma'am.
Service is taken on record.
Grateful.
I beg to appear for the statement.
My lord, I am for the petitioner, my lord. I will show only one page, my lord. That is page number 86, my lord. This is the, my lord, merit of my case. The year of 1987, my lord, I have joined with Bishnupur Sir Ramesh Institution as an assistant teacher. Subsequently, my lord, on May 29, 2000, I have been transferred to my lord with the and after that, my lord, working with respondent number 6, Jangra Adarsha Vidyalaya, in the designation of headmaster. Subsequently, my lord, at that point of time, my lord, I have selected for contributory provident fund crime gratuity scheme, my lord. Subsequently, my lord, in the year of 2014, a notification came. And my lord, according to the notification, I have switched over from contributory provident fund cum gratuity scheme to pension cum gratuity scheme, my lord. My lord, the principle of the notification was that, my lord, when I will switch over, my lord, what I have received in terms of contributory provident fund cum gratuity scheme, my lord, along with interest, I have to refund back. That I have done already.
Sure.
My lord, page number 68, 69, if your lordship kindly come. I have received 3,43,544. My lord, subsequently I refunded back, my lord, along with interest, that is 4,67,240.
Yes. Has PPO been issued in your favor?
My lord, issued in my favor.
Show me the PPO. Why are you, what do you want?
My lord.
My lord, give me few minutes. I'll explain. He's too junior. Actually, his original client is
Original
original petitioners. His petitioners.
The petitioner
Happy
died
petitioners
in the year
died in the instead.
petitioner has died.
husband of the petitioner.
Husband of the petitioner died in the year 2020. Interested in 2014, right?
My lord, husband of the petitioner were serving with the respondent number 6. He died in the year of 2020. After 2014, my lord, he was receiving the pensionary benefit. But my only grievance is, my lord, since as I have retired in 2009, my lord, 1st of April 2009, my lord, since 1st of April 2009, since I have refunded back the amount in the year of
You ought to have got it from the date of,
Date of
retirement and
retirement.
not from the date of refund.
My lord.
The date of retirement. Widow is the petitioner.
Computer আছে দেখিস কেন?
Lord, since 1st of April 2009, 22nd of September 2014, my lord, I have not received. That is my grievance.
Yes, disposed.
Grateful, my lord. নামটা দিও।
হ্যাঁ ডাকুন।
In that matter, I am for the petition.
Yes.
This is for the arrear salary with interest. So during the pendency of the writ petition, arrear salary has been paid. 9,21,000 has been paid.
When?
So I paid on 9th February 2024. So I am paying only the.
Where is the document to show it has been paid?
So, my lord, there is two file. One file is not test. There is supplementary affidavit file. I can, if you.
Where is the supplementary affidavit?
Not yet been filed, but the original copy I have not traced out. But this is the copy where the document of the payment has been annexed, my lord. 9th February 2024, during the pendency of the writ petition, the arrear salary has been paid. 9th February 2024. So I am paying only the interest.
9 lakh
21,000. Yes. My original copy, there is another file I could not test out.
And it was due from which date?
Yes.
The amount was due from which date?
From which date, my lord? It is stated in the supplementary affidavit, my lord. I am coming. Paragraph 5 of the supplementary affidavit. Since September 2007 to 8 February 2024. Paragraph 5 of the supplementary affidavit.
Please come. The instant writ petition was filed by the petitioner praying for a direction upon the respondents for releasing his arrears salary.
One thing I shall submit, my lord. A pension payment order at Treasury Officer Howrah, but the arrear salary paid, he served at Jhargram district. Arrear salary has been paid by the district inspector Jhargram. But the Treasury Officer Jhargram was not made a party. For that reason, I have filed a application for addition of party to add the Treasury Officer Jhargram as a party respondent.
আচ্ছা কি বললাম?
Should be fair, otherwise it will create difficulty.
Which remained due from September 2007. Stop. During pendency of the writ petition, the arrears salary has been released in his favor on 9th February 2024. Stop. The petitioner has filed a supplementary affidavit. No, not filed. Prepared a supplementary affidavit annexing his passbook of the bank to show that the payment was credited in the account of the petitioner on 9th February 2024. Stop. Right now, the petitioner prays for interest on account of the delayed payment of his salary. Stop. Paragraph. Anybody there for the state?
I am very sorry I could not communicate to the other side, my lord.
Just imagine
you
upgraded the matter. There is a noting that you have to give notice. You did not give.
Observe that.
You are obtaining order.
So, your lordship kindly fix it any other day. In the meantime, I say that will be better for and fair.
The court is trying to come to the aid of the litigants.
Yes, very
and
sorry.
this is how the advocates are performing.
My lord, I am very sorry.
As the original of the supplementary affidavit has not been filed before the court, hearing of the writ petition stands adjourned till 14th January 2026. Stop. Let copy of the supplementary affidavit be served upon the learned advocate representing the state respondents. Stop. As per the leave sought for by the petitioner in the connecting application, Can 1 of 2020.
One.
They can even.
Can 1 on 20.
কত item? 12. Can 25. The Treasury Officer Jhargram is directed to be implemented as a party respondent in the instant writ petition. Stop. Let copy of the supplementary ki serve korte bollam. বলেছি তো ঠিক আছে Can is disposed, make the correction immediately.
Okay, very sorry, my lord.
May I have your lordship kindly put it and request lordship. Item number 4 most likely have been dismissed for default lordship.
If nobody was not there, what can be done?
I about lordship. I have the code number 11 lordship.
Somebody should have been here. This is an updated matter.
I unconditionally apologize. So kindly make it not.
ছিল না রেসপন্ডেন্টের জন্য somebody was there. হ্যাঁ আমার মনে হচ্ছে ছিল. Side.
Mr. Biswajit De is appearing as a state law advocate lordship. I said informing course of their lordship. If you logically make it not.
What is the matter about?
It's about unauthorized exams are being conducted lordship in the school without taking permission from the board lordship. That is why that is the subject matter of the.
So this is of the year 23.
23 lordship.
The examination is long over.
Not going on private exam lordship, CA exam and all those private exams are continuing lordship despite lordship notification that effect lordship by the Board of Secondary Education lordship that without permission no private exams can be conducted lordship.
Check up who was there. Somebody possibly was there in the morning.
Lordship.
And you give notice, come at 2 o'clock.
My lord, I have this indulgence, my lord. Just to make a contempt matter. The rule has already been issued regarding the demolition of a my lord building against corporation. My lord, that was on process. But since it was fully occupied, it could not be completed within time. Today, my lord, I have been intimated, she was a junior in the matter. The my lord I would be pleased to take up the matter at 1:15. I do not know exactly. That was the direction or this.
1:15?
Yes, today.
Matter has been fixed at 1. No.
She has been informed.
I don't know who has informed how.
320, item 320, lord.
Whatever, 320 possibly was mentioned.
My lord, item number 21.
So, my lord, would your lordship be kind enough to keep in mind, my lord, my junior will be here. If
Why will you not be there?
I'll be here.
Yes, please remain.
My lord, item 21. Yesterday, your lordship was pleased to pass an order if it will be taken.
Second up.
If it will be taken up by your lordship, then lordship will kindly fix a date. I had a talk with the advocate general. He said that later date be fixed and to intimate him. They have
Excellent. In this matter, where my lord, senior my lord is mentioning before your lordship, I challenge the rule in the compassion of
They are
So yes, so this is why my lord, senior my lord has been engaged in this matter. But now, my lord, the situation is right now there, and thereafter the order of this honorable court very recently, I will not press this challenge to the rules. I will state on, my lord, just go on the merit on this matter. So if my lord, senior my lord, press my lord, is be there, possibly subject to lordship's correction, my lord, requirement of my learned senior, my lord, the Advocate General may not be required.
So before another bench, you went on to challenge.
Now,
And
this is not anymore. I tell your lordship, what is what. But after
don't tell.
After I
Don't tell.
Item 4, he is representing for board lordship.
Yes.
No lordship, but state lordship.
4, you were there when the matter was taken up.
Mrs. Bhattacharya was there.
Right. Was anybody else appearing for the respondents?
State must be appearing.
State appear করেছিল তো?
No, I don't know, your lordship.
You don't know.
Lordship, kindly make it not today. I shall notify in course of today, lordship. Kindly make it not today, lordship.
All right, I'll make it not today. File ta onion in. You check up the YouTube recording and see whether anybody was there for the state or not.
I'm also checking with GP office, lordship.
That is different. But then you check up from here also if anybody was there, serve, matter will remain in the list.
I'm grateful, lordship. May I permit? May I permit to mention one contempt matter, my lord, 345, my lord. My lord, retired gratuity, my lord, your lordship's order of 2023, my lord. Till date, they have not complied with, because my lord, no order was passed, so my lord, they have not.
I cannot help. Please wait.
My lord, old lady, my lord, retired from.
Yes, call the list.
Lord, I am for the contempt respondent number 2, my lord.
Photo pencil will be. Yes.
The contempt respondent number 2, School Service Commission. On last occasion, my lord, one.
Yes, Lordship, I on behalf of the petitioner, Lordship. Last occasion, there was a direction to the DI to forward the application to the West Bengal Central School Service Commission. Lordship, till date, the order is not complied, Lordship.
Yes. Date DI.
Lordship.
Mr. Bormon.
Lordship, we have tried to make alternative that could not be made. We have informed to the school service commission because they are the authority to take the final decision.
Where is the communication to the commission?
Lordship, we have supplied to the petitioner yesterday.
Lord, kindly, Lord, I have handed up a document of 8th of August 2025.
Thereafter,
that is the decision of the school
around
service.
21st November, we have again sent the copy.
It cannot be. The order of the division bench in Rupok Dua is very clear.
In this repetition, my lord, the order was passed for alternative arrangement. My lord, strict adherence of 3rd January.
Maybe now it has changed. It has to be done, as is the present law. Please come.
Lordship, more than 1 year has been
Submission
passed, Lordship.
But in contempt jurisdiction, my lord.
Made on behalf of both the parties. It appears that alternate arrangement for engaging a teacher in case the petitioner's application for transfer is allowed could not be made by the District Inspector of Schools, for which the Commission has expressed its inability to consider the petitioner's request for transfer. Stop. Whether the application for transfer can be kept pending indefinitely in the absence of a willing teacher to perform the work has been decided by the Honorable Division Bench of this court in the matter of Rupok Dhua. একটু দেখে নেবেন তো আমাদের কাছে আছে ট্রান্সফারে সিঙ্গেল টিচার যেগুলোতে আছে সেখানে পেয়ে যাবেন ঠিক আছে প্যারাগ্রাফ
FMA 995 of 2025.
As the law has been settled by the court, the authorities ought to act in accordance with the same. Stop. The contempt application is made returnable on 19th February 2026.
Lordship, earlier occasion, my lord has directed the same order, Lordship.
Acha. The fate of the petitioner's prayer for transfer shall be made known to him prior to the adjourned date.
19th February.
Item number 2. Grateful, Lordship.
Last occasion directed to serve the order of the court, Lordship, I have served.
But in item numbers 2 to 12,
My lord, 2 to 13, 12, there are 11 matters. My lord, in all these 11 matters, an appeal had been preferred before the Honorable Division Bench. My lord, only day before yesterday, the Honorable Division Bench was pleased to dismiss the appeal and direct compliance of the order of the Honorable Single Bench. My lord, the copy of the certified copy has been applied for, yet to be obtained. My lord, only thing I am submitting is that, my lord, some time is required to carry out the compliance of the order. My lord, grants at least 4 weeks time. In the meantime, the order will be complied, my lord.
Are you aware of the appeal codes? Show me, please. What was the direction?
My lord, there is shortfall in service. Pensionary
was for consideration of representation.
consider the
representation in terms of
in the light of Paresh Chandra Rai,
Paresh
sir, my
Chandra
lord.
Rai issue. Already
Yes.
Paresh Chandra Rai issue also state prefer appeal and appeal also dismissed. Lordship. That I have annexed in the writ petition and complied the order. PP
Please
has
come.
been issued.
The judgment passed by the Honorable Division Bench on 6th January 2026 in MAT 124 of 2025. State of West Bengal and others has been placed before this court. Stop. It appears therefrom that the appeal preferred by the state challenging the order passed by this bench stood dismissed. Stop. The learned advocate representing the contemner seeks time to comply the direction passed by the court. Stop. On such prayer, hearing of the contempt application stands adjourned till 19th February 2026. Stop. An affidavit of compliance shall be prepared and circulated prior to the adjourned date.
Grateful, Lordship. Grateful. Extremely grateful.
Lordship,
Same order will go down in all the matters.
what is the name of the councils?
Name of the council will be different.
It will be called on one by one.
Lordship.
The order will be the same. It wait karo.
নামগুলো বলে দাও।
সার্ভিসটা রেখে দিন। ফাইল দিতে হবে না। শুধু লিখুন the judgment passed by the Honorable Division Bench on 6th
order of the appeal, Lordship.
Oh, you are giving order separately?
Yes, Lordship.
You've got order so many copies?
Yes,
তাহলে same order করে দিন। All right. Who's for the contemner in 3?
3 is Pritam Das and Saurabh Sarkar.
Please put down in the chat box so that the appearances can be recorded.
Grateful, Lordship. Grateful.
ডাকবেন।
Here also affidavit of service and appeal.
Item number 4, Mominur Rahman and Pradeep Sarkar.
No. Item number 4 is Shubhi Sarkar.
Oh, item number 4 is Shubhi Shah and Shubit Kumar.
Also, in that case, there is no appeal, Lordship.
No appeal?
Yes, Lordship.
No.
Item number 5.
Yes, Lordship.
There is no appeal, I am told.
Item number 5 is not in our list. Yes, there is no appeal in item number 5.
Lordship, here we do
Separate appeal, separate contempt, Lordship.
That's a separate matter, my lord.
Separate matter?
Separate matter, Lordship.
Let me see.
video, Lordship.
ওখানে গিয়ে নামটা অ্যাড করে দেখি ঠিক আছে
What is the order passed here?
53, page 53.
Yes. Condone the shortfall. Employee is no way responsible. Yes.
Not appeal, my lord.
Then the order is to be complied, isn't it?
Yes, that is to be complied. It grants the
Order
same
of the
time. my lord.
court.
Yes. But
We are not appealing
first.
on this matter, Lordship.
Who is appearing for the contemner?
But we have not been instructed in this matter.
Nobody
We
is
have not-
appearing.
No, we have not been instructed
Nobody.
in this country.
But then the copy has been served.
My lord, keeps it, my lord, adjourns it, my lord, I'll have a word with the department. It's the same department.
আচ্ছা তাহলে লিখুন none appears on behalf of the contemner.
Lordship, Lordship, one small indulgence, Lordship, we are unable to give the names in the chat box as the host has disabled us to give the names.
All right. আচ্ছা কি বললাম on behalf of the contemner stop. Contemner despite service stop. Affidavit of service filed in court is taken on record. Stop. The to provide an opportunity to the contemner to comply the direction passed by the court. Hearing of the contempt application stands adjourned till 19th February 2026. Stop.
Gratefully.
An affidavit of compliance shall be filed on the adjourned date. The issue appears to be the same. State councils.
Yes,
All
yes,
right.
my lord. I'll take it up with the department.
Condonation of the shortfall.
Shortfall in service.
Please comply.
Lordship, will.
Appeal was there? All right, then same order as.
This is Mominur Rahman and Vikas Singh, state for the alleged containers.
Please put down your appearances. The
Yes,
host has.
Lordship, it has been
forbidden
disabled.
you.
We are unable to put in a.
No, he has enabled you now.
No, yes, we are putting. My lord,
We
after
are
this,
putting, Lordship.
we will be putting it. All there are 11 names, my lord. It will
All
take
right,
some time.
please put in the names.
Yes,
Grateful, Lordship. Grateful, Lordship. That's it.
And lots of same as 5.
12 is same as 5. That means no appeal has been preferred.
No,
12
no,
is
no.
anybody appearing?
No, my lord. Priyanath Das is no.
Same as 5.
Same as 2.
Yes. And then
No
4.
appeal filed?
But next,
13 appeal filed?
Yes.
All right, then appeal
Yes,
copy is
Lordship.
there.
13 and 14.
13 and 14 appeal filed.
Appeal filed. Why did you pick up and choose to file
But
appeals?
only
After
only
serving the
11
notice
matters
of
were,
contempt, Lordship, they preferred appeal.
only 11 matters were sent to us for filing appeal.
Why the other 2 left behind? 2 and 3?
We are not aware of that. It was not sent to us by the department.
Anyway, I have fixed all the matters on the same date. Please
No,
file
no,
your
we'll take it.
affidavit of compliance.
Lordship, will be.
Grateful.
Yes.
Grateful, Lordship.
Grateful, Lordship. That's it. এবার করো।
Item number 1, 2, application from the daily.
152.
152 application.
My lord, your lordship pleased enough to actually showcase my officers for doing out their job. And my lord, the 2 officers are here because my lord, the
Officers have retired.
my lord, no retirement because my lord, the first officer who is actually incumbent upon borough 4 and 5, his actually wife is actually Ray, and due to the cancer, he is not doing the duty properly. So officers change, and the newcomer has come, and both the officers are here, your lordship, and they have, my lord, went there repeatedly along with the police. My lord, the here is my lord, that is focus. He was kind enough to actually. That also I stated that officers had newcomer and order was passed after coming. If your lordships kindly see the order, that is
The original contemner over here, I see Mr. Amitabh Mukherjee.
My lord, he is here, my lord.
Yes, his wife is unwell.
While unwell in the sense, my lord, there is cancer and chemo
Yes.
and other things is going on.
So he is not performing his duties.
My lord, name should be changed because he is not performing his duty in the sense, my lord, this is in case of my lord, that is Boro 5. And he is actually 4, 5 both. Now he is actually seeing Boro 4 only. 5 is new officer, my lord, Prabir Kumar Datta. He is actually coming newly. That is actually also stated in paragraph 42.
And when the order was passed, Mr.
My lord, your lordship
Mukherjee
passed
was
the
there.
order on September 2023 and 2024 newcomer actually just coming and passed the order for actually other
So 24 from the date of the order, on the date of the order, Mr. Amitabh Mukherjee was there.
No doubt, my lord, there, but my lord, he is, my lord, repeatedly actually taking to leave from the office actually to
How will
serve.
the works be
I am
done?
not actually, there is nothing to
If
say, my lord. I am not
the
actually, I should
officer
not.
takes leave.
Leave in the sense, my lord, when someone's officers, my lord, that is wife, my lord, she is actually taking
Listen,
care
then
of.
somebody must be there in charge to look after all these things.
That is the assistant engineer was there.
Then?
Then, my lord, Amitabh Mukherjee, and then, my lord, he is the present incumbent, Boro 5. He is actually going there. There is photograph also went there. My lord, if your lordship is kind enough to actually, that is page 51, if your lordship kindly see. If the enterprise, my lord, kindly.
152 আমারটা
Yes.
May I submit one thing, my lord? For the petitioner? In the meantime, what happened, my lord? The petitioner has been threatened by the persons who have made the unauthorized construction. My lord, mail has been sent to the police authority also.
Oh, petition, read petition.
Oh.
Kindly, my lord, consider the load of the
Yes, what happened? Page 51 you are showing.
My lord, page 51, my lord, we are actually, what I am want to show, my lord, that is, we actually tried our level best. Your lordship knows the law, my lord, that is, without vacating and other things, we cannot.
On one hand, you permit such unauthorized construction to be made, not being careful to see that these type of unauthorized work is restrained or prevented. And on the other hand, when the occupants are there, you say that the occupants cannot be vacated and so the unauthorized construction cannot be brought down. This is the stand of all your authorities, right?
My lord.
The officer standing over there does not know there is an unauthorized construction just by the side of the corporation. What are the officers doing? They can't see.
My lord, your lordship, I understand, my lord,
This is not a question of understanding. You see what the petitioner is saying. There is a threat given out to him.
The mail has been sent.
And your photograph also suggests that see the number of crowd that is over there. And it is your officer who permitted this to percolate to that extent.
My lord, that's why, my lord, your lordship on last occasion actually directed the officer in charge of the police station for actually. Your lordship knows that after, without vacating, my lord,
No,
so
the
many.
officer in charge will
Your
not be in a
lordship,
position to do it.
my lord, may I submit one thing, my lord? So
Yes,
many
please.
things I actually appeared before your lordships, and in each and every case, my lord, that is the demolition of the building actually take care of and demolished that is last brick. Your lordship knows so many matters. My lord, in this matter today is my actually, I am actually fast appearing my misfortune or fortune, my lord. But my lord, the thing remains, my lord, this is my show cause regarding the officers actually why they are not taking steps. My lord, give us some more time, my lord. And regarding the petitioners, my lord, what mail is actually produced before your lordships, I can say this, my lord. This is not for saying your lordship knows that so many persons without any standing comes. No doubt building is unauthorized. There is other consideration I cannot actually should not say before your lordship. And
That
thereafter,
is-
my lord, I actually complete. My lord, please, my lord, kindly allow me to complete. And thereafter, my lord, that petitioner is actually sometimes, my lord, is not there. Their persons come and doing other things, mischief. I don't know what is the actually mail actually sent by my learned friend. My lord, give me some time today. Actually, I took over
Some
this.
time for what?
My lord, your lordships,
What will you do with
my
the
lord,
time?
my lord, may I say something, my lord? On other cases, my lord, your lordships directed electric office to actually disconnected the electricity. Your lordships help us, and other things, my lord. That is the water connection may also be disconnected. That direction and the hierarchy of the.
So your officers cannot work
My lord,
independently.
your lordships actually
They
asked.
always want
My lord,
the order of the court to act as a shield in front of them. The law doesn't give them any authority. They want the court to stand by their side.
My lord, because my lord, there is your lordships. Actually, I am here to actually take all those wrath of your lordships. I am grateful to your lordships, but the thing
The wrath of the problem which the litigants are facing.
Yes,
The court is not here
absolutely right.
unnecessarily making all these comments. It is not for any reason that these comments are being made. And that is the reason on one occasion in one of the matters I have passed direction for deploying paramilitary forces if the state police is unable to do it.
Your lordships actually hierarchy of the police officer.
Yes.
And disconnection.
Right.
Your lordships, and the thing remains, your lordships asked me on questions how the building comes up. And my lord.
Please tell your officers to remain vigilant and work with their eyes open. They only sit over there and I know what happens. And if you want me to say what happens, I can, even you know that I know it.
My lord. Absolutely correct, my lord.
From the corporation building itself, illegal works are being done. These people cannot withstand the pressure coming from the other authorities. I can understand.
Absolutely.
But let them not be party to all these things. When was the order passed?
September 2023. And my lord,
September
my order.
23.
Your lordship's order, but
imagine.
My lord, your lordships directed me to actually pass the order. So I passed the order in 24.
All right.
September.
So from 24, you found that the building is unauthorized. Couldn't take any steps. How helpless y'all feel. The court is feeling bad for y'all. You pass an order, you say this is unauthorized, you want it to be demolished, but you cannot. Absolute toothless officers. Please come. Leave is granted to the advocate on record of the petitioner to implead the present incumbent as party respondent, party contemner in the contempt application. Stop. Next.
152 and
A show cause by affidavit has been filed on behalf of the present incumbent. Explaining as to why steps under the Contempt Act should not be taken against him. Stop. Prayer has been made to extend the time for filing the affidavit of compliance. Stop. In the show cause, the executive engineer has annexed photographs in support of the submission that despite efforts to demolish the unauthorized construction, the same could not be demolished because of resistance by the occupants of the said structure. Stop. Next. The contemner is directed to take immediate steps for disconnecting the water supply connection to the subject structure. How could the water supply be affected to a structure which is unauthorized? Who permits you to do this? Does the law permit you? There is no occupancy certificate given, and you go and give water connection.
My lord, that probably, my lord, the original, that is the building, probably the water connection
Was
also.
given over there, and thereafter everybody is using it.
My lord, that is the probably, no.
Acha. The Commissioner of Police is directed to take necessary steps for providing adequate police protection to the men and agents of the corporation at the time of implementing the order of demolition. Stop. The executive engineer of the corporation is directed to communicate the electricity service provider to immediately disconnect electricity to the subject structure in aid of demolition of the same. Stop. And how big is the structure?
5 story, no?
3+4 possible.
The entire building is unauthorized.
Yes, ma'am.
G+4.
Yes. Entire building is on.
Where is it? Keshab Chandra Sen Street. There is hardly any building in this lane which is legal and authorized. Hardly any. And you appear in these matters and you know. Right? Achha. And all Thika properties. G+5.
My lord. Let's say the hard story.
The matter is made returnable on 12th March 2026. Affidavit of compliance shall positively be filed on the adjourned date. Stop. The learned advocate for the petitioner has drawn the attention of the court to the fact that the petitioner is being threatened with dire consequences if he proceeds with his complaint alleging unauthorized construction. Stop.
My lord, at the bottom, my lord, will find that voice clips have also been seen.
The Commissioner of Police and the Deputy Commissioner of Police North Division have been intimated via electronic mail by a communication by the petitioner dated 6th January 2026. Stop. The Commissioner of Police is directed to ensure that no harm is caused to the life and property of the petitioner in any manner whatsoever at the hands of the petitioner, at the hands of the persons responsible for making the unauthorized construction or the occupants and agents of the said person. Stop. The officer in charge of the Amha Street Police Station is directed to keep strict vigil over the property and ensure that all order passed by the court, all orders are duly complied with. Stop. The petitioner is directed to communicate this order to the Commissioner of Police, comma, Deputy Commissioner of Police, North Division, comma, officer in charge of Amma Street Police Station, and to the electricity service provider of the subject structure.
Well, only one thing, my lord, liberty may kindly be given, my lord, to respond to the show cause notice if occasions were.
No use. Show cause is to the court. Show cause is not to you.
As my lord.
Yes. Personal appearance of the contemner stands dispensed with for the time being.
I'm grateful, my lord.
Same order.
Same building?
No, building is building same petition.
How big is it?
Petitioner is same. The
Petitioner may be the same. Structure is different.
Structures, my lord, there is unauthorized construction. my
How
lord.
big?
I'm telling, my lord.
This is at a different place.
Yes. that
This is
the
not.
case, my lord, more or less, my lord, same order, similar order was passed.
Yes. And same Borough 4 and 5.
Yes, yes.
Borough 5, lordship. Yeah.
Borough 5. My lord, may remember there were, my lord, as many as 5 cases.
Amma Street Police Station. Is there an affidavit to show cause also over
My
here?
lord, my lord, this is also there. It is to. My lord.
Same order may go down.
166 to বলুন।
এই 166 তুমি এনেছো?
Do one thing.
163
এই মামলাগুলোতে না অ্যাড্রেস গুলো লিখে দেবেন। ওই ছেড়ের অ্যাড্রেসটা।
166 is also the same, my lord.
Same order.
আগেরটা কেশবচন্দ্র সেন স্ট্রিট আর পরেরটা কি পাটওয়ার বাগান লেন নাকি?
166.
ঠিক আছে?
My lord, have you lordship pleased enough to actually take 166? The same petitioner and respondents advocates are here.
166 is also the same.
The same.
Show cause there?
Show cause is there.
All right, then the same order.
Here is.
Is it the Amma Street Police Station?
My lord, the Borough 5.
Check up which police station?
Only Nakeldanga.
Narkaldanga Police Station. And here also did you get threats?
No, here, my lord, no instruction is there.
And in the last matter 153? আচ্ছা থ্রেটের ব্যাপারটা ওখানে কিন্তু বাদ যাবে 153 আর
My lord, I
166
sleep as such, whether it covers both the premises under Amma Street Police Station or not, that I cannot say.
Are the premises adjoining?
Nearby, my lord. Yes.
Near, I mean, there is different road
Borough,
now.
Borough
Name is Borough is 5 different premises.
What?
The petitioner is
Occupants will differ, isn't it? I do not know. It is if you do not have any copy, then
Yes, yes. That's
grateful. Lordship.
make the necessary impleadment. Let your on record make the impleadment of the new incumbent.
Yes.
Yes.
154.
Yes.
Lord, this is the photograph. Lord, your lordship, kindly see the last order of your lordship, my lord. Whereby, my lord, your lordship directed them to demolish the outer wall, and the assistant engineer Borough 2 is directed to remain virtually present in court.
He is in
My lord,
appeal.
I don't know, my lord.
Show me the photograph.
Yes.
But I am with the photograph, sir.
Please give. Where is the assistant engineer?
He is in online. Listen.
Now, my lord, kindly see, this is the photograph. আর আমাদের একটা ছবি দিন।
দিচ্ছি দাঁড়ান।
So substantial demolition took place?
My lord,
Substantial demolition took place?
my lord, kindly see my photographs, my lord.
Show me the photograph.
Yes.
And after
My lord,
today's
this is
demolition,
the-
my lord, letter has been given to him to give us a comprehensive report that whether any
Yes, yes.
further demolition
Yes.
required or not. That also letter has been given, my lord.
All right.
My lord, kindly see, my lord.
Show the photograph, please.
This is the photograph.
He is in online.
All right.
This is the photograph. Now, my lord, Kindly see his letter, my lord.
I have given
Now,
the
my
latest
lord,
photo up to yesterday. My lord.
kindly see, this is the third floor. Now, my
So
lord,
even your photograph shows that substantial demolition took
my lord,
place.
so far that outer wall, your lordship specific direction was.
Yes, the outer walls have been demolished. The columns,
outer-
the pillars are there.
My lord, your lordship, kindly see the big photograph. This is the outer wall, my lord. This is the outer wall. Third floor outer wall.
One side, not. One side, not.
That is intact in the one side, my lord. Nothing has been done. Nothing has been done, my lord. And kindly see, my lord, I have stated in details. And beams, all the beams are there, my lord. Your lordship.
Yes, the pillars I can see are there. That will be brought down.
Yes.
But then the outer walls.
Outer walls, your lordship, kindly see one side, my lord, entire, but one time side remains.
All right. Now
Yes.
there is a letter from the corporation.
Yes. Now, my lord, kindly
Asking you to say which
Yes.
wall is to be demolished.
Kindly see the second line, my kindly see that.
Huh?
But again, recently from 3rd January onwards, whole of the outside wall of the second floor demolish our team. Absolutely false, my lord. I have given the photograph today. This is the today's photograph.
I have given the photographs of yesterday. My lord. Today is no
Today-
photograph because today no.
All right.
Yes. Now, my lord, and it's
This is
running.
which side? This is which side?
But this is
Which side?
this is the front side.
Front side.
Front side, road side.
This is the road side.
This is the road side.
And the other side of this,
Other side, my lord, I have given the photographs. Your lordship kindly see.
your other side shows that the demolition took place.
Other, so far the roof is concerned.
No, not the roof, even the outer walls.
The outer walls, my lord, your lordship kindly see. Kindly see the second photograph, figure 3.
Say figure 3.
Figure 3, your lordship.
Top one has been demolished. The bottom one remains.
Bottom was so far the third floor is concerned. Side walls is remains.
Left hand side.
Left hand side, your lordship kindly see.
Yes.
That is intact. And my lord, so far the top floor is concerned.
Overhead tank.
Your lordship kindly see, room is there.
Overhead tank.
Room is there.
All right.
No, not room. That is overhead tank, my lord.
And my lord, kindly see the beams.
Yes.
Pillars are all
No,
there.
the pillars, the corporation photograph also shows the pillars are there.
Pillars
All
are
right.
there. Now, my lord, kindly see. I have given the arrow marks, my lord.
And what is the extent of the unauthorized construction?
Extent of entire second floor. Your lordship direction was that the entire second floor to be demolished, as well as the so far the deviation part of the ground floor and the first floor is concerned. No, that so far the deviation part is concerned, nothing. No trust, my lord.
All right. The engineer. Photographs of the corporation has been placed before this court. Now it appears that the pillars are still there. How soon can they be brought down?
My lord, all the RCC column already been stand still as because they are ওখানে আপনার structurally পুরো বাড়িটা ultimate dismantle without ভেঙে পড়ে যাবে যেহেতু structurally disabled আর one side of the wall যেটা attached of the adjoining building ওটাকে ভাঙা যাবে না 59/A/1 the wall that wall is also common by the same 59/A/1 and 59/A/1/2 এটা হচ্ছে actual fact আর remaining both peripheral wall also front side already dismantled by us from 3rd January and onwards.
The wall that is remaining, is there a room over there?
Nah, only stairhead room is stand still. It above G+1. No room has been there.
No room. The wall,
No room.
that photograph has been shown that a wall is there, absolutely intact.
Yes.
Is the wall a part of a room that is being used or anything of that sort?
No, ম্যাডাম ওখানে সেকেন্ড ফ্লোরে এখন পুরো ইনহ্যাবিটেবল কন্ডিশন, কোনো রকম ভাবে কেউ বসবাস করতে পারবে না, অনলি ডেব্রিস কিছুটা আছে, যেটা এখন পুলিশ প্রশাসন আমাদের হেল্প করতে পারবে না ডিউ টু গঙ্গাসাগর মেলা, এবং মানে এতে ওইটা খুব ভেরি শর্টলি আমরা ওটাকে ওখান থেকে ডেব্রিস গুলোকে সরিয়ে দিতে পারি, কিন্তু ওখানে কোনো রকম আর ওই বাড়িটার সেকেন্ড ফ্লোর কোনো রকম ভাবে হ্যাবিটেবল কন্ডিশনে নেই।
And the unauthorized construction is above the second
Okay.
floor.
So far, unauthorized is fully unauthorized, second floor, and so far the ground floor to up to first floor.
That is the deviation.
Yeah, that is the deviation. Your lordship direction was also
Yes.
that. And your lordship order was tested before the division bench.
No, it's all
Yes,
right.
Your lordship, last time I have handed
Not by
over.
us.
Not by corporation, not by corporation.
Deviation. Has
Yes,
those
yes.
portions been demolished?
না, ground and first floor has deviated also, but no, there is মানে সেখানে কোনো রকম হাতি দেওয়া হয়নি, still dated.
কেন?
As because সেকেন্ড ফ্লোরটা ভাঙার অর্ডার হয়েছিল, অনলি ফর সেকেন্ড ফ্লোর আমাদের ইনস্ট্রাকশন এসেছিল যে সেকেন্ড ফ্লোরটা ভাঙার জন্য।
কে ইনস্ট্রাকশন দিয়েছিল?
যেটা অ্যাকর্ডিংলি মানে হায়ার অথরিটিস যে ডিসিশনটা ছিল যে সেকেন্ড ফ্লোরটা ইমিডিয়েটলি আমাদের আনঅথরাইজ যেহেতু অ্যাজ পার সেইটু ওটা আগে ভাঙা হোক।
আর
কিন্তু ডেভিয়েশন পোরশন,
ডিভিয়েশন যেগুলো হয়েছে সেগুলো কি ডিভিয়েশন যখন বলছেন তার মানে তো ওটা আনঅথরাইজড।
হ্যাঁ এক্স্যাক্টলি ম্যাডাম, ওটা স্যার ম্যাম ওটা আনঅথরাইজড, বাট ওখানে স্ট্রাকচারাল অ্যাকর্ডিংলি মাই কোয়ালিফিকেশন অ্যান্ড এক্সপিরিয়েন্স, ওখানে আমি একাধিকবার আমি বলেছি যে ওখানে একটা মানে স্ট্রাকচারাল কোনো কাউকে এনলিস্টমেন্ট করে দেখা হোক যে হাউ it is possible to remove মানে dismantle the unauthorized deviated portion of the ground and first floor, as because the all the structural member like that RCC column are on মানে only deviated portion they are মানে সেগুলো সব কটাই ডেভিয়েটেড পোর্শনে আছে। ডেভিয়েটেড পোর্শনে আরসিসি কলাম যদি আমরা ভাঙি তাহলে স্যাংশন পার্টটাও অটোমেটিক্যালি ডিসমেন্টেলড।
তাহলে একটা স্যাংশনকে বাঁচানোর জন্য যেটা আনঅথরাইজড আছে সেটাকেও বাঁচিয়ে রাখতে হবে, এটাই কি আপনার বক্তব্য বিষয়?
না না, আমার বক্তব্য বিষয় নয়, কখনোই নয় এটা, কিন্তু ওটা কি করে ভাঙবো এটা আমার হায়ার অথরিটি একমাত্র এটা ডিসিশনটা নিতে পারেন, মানে আরো আমার যারা সুপিরিয়র বস আছেন।
প্রথমত আপনারা খেয়াল রাখেননি যখন আনঅথরাইজড কনস্ট্রাকশনটা তৈরি হলো, তারপর যখন হয়ে গেল এখন বলছেন যে ভাঙা সম্ভব নয়।
না মানে এটা বলা আমার যেহেতু মাই লর্ড এটা আমার বলা উচিত।
Only one thing, my lord. So far as the G+1, that is deviated portion, he is thinking that may cause demolition of the entire building. But I will ask him and instruct him to demolish the deviated portions after leaving the extra, that is the planned portion, that he will do. If your lordship give me some time. And so far as that wall, that is a common wall that your lordships has already heard from him. The common wall, it is very difficult, but still, if your lordship want a special officer to be appointed there, he will see that what is the position of the building. But still, I am saying, but if your lordship give some time, I will go on demolishing the deviated portion.
The photographs produced by the petitioner and the corporation in court today, we retain with the records. Stop. The assistant engineer Borough 2 of the Howrah Municipal Corporation is virtually present. Stop. It appears that demolition, substantial demolition, has taken place in the top floor of the building. Top floor of the unauthorized construction, but the deviated portions have not been touched. Stop. The pillars of the unauthorized construction are still there. Stop. To allow the corporation to remove balance unauthorized construction, hearing of the writ petition contempt application stands adjourned till 12th March 2026. Stop. Further affidavit of compliance shall be filed before the court on the adjourned date.
Along with pictures. And so far as
It will be open for the parties to produce photographs of the structure on the next date.
Contempt number one
My lord,
is not a-
let my photographs be kept on the record.
Yes.
Yes.
contempt
And my lord,
number
one thing, my lord,
একটু
may I
বলতে দিন, এটা বলতে দিন। Number one, Dhawal Jain.
No longer there.
No, he is in Birbhum. So
All right.
let his name be.
Has new one joined?
A temporary one joined.
All right.
I
Not-
don't know whether he will remain or not.
All right.
But in any manner, we are scared, we will do it by March 13. In any manner, but one thing, the special officer may be appointed. Because special officer will see what type of building has been.
Let us see. Not today.
And
The
the personal appearances will be there, madam.
personal appearance will be there. You want him to be personal?
No, I want that is waived.
All right.
Let him come
Personal
after,
appearance.
otherwise.
Personal appearance of the engineer stands dispensed with for the time being. Be it recorded that the contender number 1 has currently been transferred from the said post. Stop. New incumbent is yet to join. Stop. Next.
My lord, only one thing, my lord. Kindly add it online. My lord, this is the all the garbage. Ma'am, I cannot.
All right. The corporation shall take steps
To
remove the debris.
Debris in the
Yes.
passage. Deeply.
Returnable is 13th March.
It is 12th of March. Is the school there?
For the secondary board. Earlier of the directing the DI to inform.
Anybody from his chamber? Please tell him to come over here.
On the last of your lordship directing the DI to inform the school. This inspector have already informed the school.
Is anybody there for the school? What is the issue about?
There is no evidence of any such school.
There is no school.
No. And name and style of Narayanpurli Madhyamik Vidyalaya. Subsequently, name has been changed. Ratanlal Saragi Madhyamik Vidyalaya. And all the teachers have been transferred. Roll strength is 0. And
Let me hear what the matter is. Yes.
This is in fact the 4th round of litigation, lad.
All right.
And in the 2nd round of litigation, after the rescind order was passed, High Court passed this order at page 44.
Yes. 2003. It is a 2003 order.
2003 order.
Yes.
This order, the same dispute that which is the school in which I was working and the school they are claiming. In fact, the same school, they have changed the name at the time of recognition and they recognize me as a teacher of that school.
Mm.
That was the issue.
Mm.
By this order, Honorable High Court said that
this cannot be decided in a writ petition.
Hmm.
So, my lord, I file a suit. Now, suit court has passed a decree, judgment decree. That is at page, my lord, 47. Relevant part is, my lord, at page, my lord, for 57. Suit court has declared that the
Did anybody represent the principal secretary, school education department before the trial court?
and board was made a party possibly. But at page, but yes, at page 59 is the decree copy. Principal secretary of the government of West Bengal was party. District inspector of school was party. Secretary managing committee was party. Now, my suit has been decreed in my favor. Now the only
For the defendants.
yes. Now, my only short question now involved whether this writ court can take into consideration the decree of the court.
1 minute, Mr. Bari. One leave you obtained in the morning. I do not remember that you mentioned before the court that the matter relates to Jalpaiguri.
One of the while considering the SSC recruitment related issue before the Jalpaiguri bench, your lordship observed that SSC recruitment related matter should be filed before the principal bench.
No, never. Never it was. Sorry, sir, you are absolutely misinformed. So this is a Jalpaiguri matter. It will go before the Jalpaiguri. The bench is functional over there.
Since we are lordship of
So leave. No, sorry. It was a wrong information given to you. Yes.
Now, with only issue is involved, that now by this decree, I was allowed to serve in this school with effect from 1998, January. That's the decree at page 61. Rather, 6 from 60. This suit coming on this day for final disposal. Now, in the second paragraph, it is ordered that and decreed that the instant suit succeeds on its party in part, but without any cost. The plaintiff do get decree for declaration that the plaintiff are entitled to render their service as assistant teacher in so-and-so school since 1998. Now, I have found a judgment of 2010 where Supreme Court has held this similar should involve. The yes, the court can take into consideration this decree and pass consequential orders. Because after this decree in 2016, I wrote a letter to the school, allow me to join. They didn't allow. Thereafter, this writ was filed. Now, this decree needs to be implemented by.
So why don't you go for execution of the decree before the court?
This is in the form of declaration.
Yes.
Therefore, it may not be enforceable in civil court. That's why the similar issue was crafted up before Supreme Court. This judgment was passed.
Rotunlal. What is the name of the school? Rotunlal?
Previously name is, my lord, Narayanpulli Madhyamik Vidyalaya.
No, the decree mentions about Rotunlal Sarogi.
That's the name in which I was re-recognized. They have changed the name at the time of recognition of the school.
Yes.
And they say that you were working in the name that was mentioned in Narayanpur, not in this Rotunlal.
All right.
This was the recent decision that was challenged in a rate.
When were you appointed according to you?
In 77, 78, at the time of as an organizing teacher.
Now the organizing teacher concept has gone.
At the relevant point, it was there.
It was there. Now what can be done?
At the relevant time, I was the organizing teacher. Therefore, I am entitled to
the organizing teacher because there is no record. The school does not exist. This is what the DI says.
Yes. They say that the school that you are claiming is not the same school
This is the report
in which I was working.
I'm obtained.
Now the civil court.
Yes.
The civil court, High Court has relegated me to the civil court. While I challenge the reasoned decision, the reasoned decision speaks up. If you kindly takes up the reasoned decision once.
Decision is absolutely inexecutable.
Is 39, my lord. There is no evidence of any school
Give a copy to him. Give a copy to him. There is no evidence of any such school by the name of Naranpur.
Yes, that was the issue raised.
The present school is Ratanlal.
Yes.
Recognized by the board 2000. 2000.
Never worked. That's bad.
2000. Subsequently, 6 assistant teachers have been appointed in 2001 and all these things. Petitioners were never appointed as teachers by any authority to Ratanlal. All right. Ratanlal has never been known by the name of Naranpolli. This is also the statement. Ratanlal had never been known by the name of Naranpolli. Rather, Ratanlal has been renamed as Ratanlal Charaugi such and such. 2006. They were never. So, what is there in your support?
Page 39 left. This was the reason decision passed
And the principal secretary.
by the principal secretary. Same plea was taken in the reason decision. Paragraph 4.
Assuming these disputed question of facts, the court
Cannot be decided by the writ court. And that for that reason, the writ could delegate the matter to the suit court. Now in suit court, this has been decided in my favor. Now the plea now they have taken, that they are taking, has already taken in 2003. Now suit court has passed a decree against them. Therefore, the plea that they are now taking cannot be taken now any further.
Firstly, the suit was an undefended one.
Yes, expertise.
Then,
That's not my fault.
may not be your fault, but for the purpose of getting the order executed, the presence of the school is required. Ratanlal doesn't have any document to show that you were in service before in that school.
Lad, they are denying. That's my case. I am fighting since 2003. This is not the first time I'm approaching this court.
What is the observation of the trial court shows?
And consummate page 47. The case record is taken up for passing order. Since independence and partition of India, innumerable evacuees crossed over this country, and a large number of them started settling down in the vicinity of Narayanpolli, Ramkrishnapolli, Durganagar, and so areas. Sometime in 1978, a school named Narayanpolli Madhyamik Vidyalaya had been established in the vicinity of the Narayanpolli post office, PS Swanso, by the active patronage of financial aid and assistance of a number of inhabitants of the said locality to impart education to the people belong to the backwards community, especially the scheduled caste and scheduled tribe. Sincere effort, toil for the establishment to the school, flourishing the span of classes, enriching the art of imparting education, and to ensure the overall welfare of the students, and to increase the reputations as well as for getting necessary sanction, recognition of the defendant number 1 and other concerned authorities subordinate to it. The plaintiff number 1 appointed in so year, then 3/4.
See, the learned trial court absolutely took into consideration whatever you submitted before the court. You were appointed, you did this, you did that, but there was no one to oppose. So it's an undefended suit. Now the observations. Usually the trial court is not aware of the organizing teacher rules, what happens to secondary education, the mode of appointment, all these are not dealt with by the trial courts. Now the court doesn't know as to what is
the issue before the court was whether two schools is same or different.
Oh, if you want that, you be happy that two schools are same, but the court is not going to pass any order in your favor. I'm sorry, sir.
Sir, kindly visualize the situation from 2003. The same question is being raised by the state. that the school in which you were working is not the school has been recognized by the state.
Assuming that you were there as an organizing teacher, there is no scope for your regularization.
No, I'm not. What is the dispute and why I am being denied of benefits? I was served until 2003 from 77.
How could you? Firstly, I do not know. How could you?
Because the school allowed me. And now let kindly see 2003 that took this plea. The school is different. Now it was challenged by the writ court. Writ court granted me liberty to file suit. And
assuming that the school's name had not been changed, even then, do you have a right?
that I am before the writ court to argue the scope of the writ petition and the claim benefit and the prayer, the relief I am seeking from the court. Now, let here you cannot enter into the findings of the suit court. The findings of the suit court is binding upon all the parties present here.
Yes.
Because I have made a communication to the authority that this decree has been passed against you. Nobody bothered to prefer any appeal against this.
They are not concerned because they say that this is not my school.
No, the decree of the civil court binds them. They cannot say that the civil court's order doesn't bind them. Therefore, whatever observation, ex parte or contested binds them. An authority cannot say that I will not follow the decree of the civil court. That scope is nowhere. Now I am before the court. Again, the same plea that I have taken in 2003, that the issue that they have taken, that the point that they have taken in 2003 is no more res integra. Now you cannot say that the school are different to deny my benefit. They have to now accept and proceed that the school are same and I was working in that school.
Sir, sorry, sir. Please, I am not with you and I do not want to spend more time in this litigation.
Kindly take some of the judgment I have cited in
yes.
2010.
Yes, 2010 4 SCC 568.
Now let kindly see paragraph 2.
Yes.
Petitioner, employees of the HON'BLE Education College, private college recognized by so-and-so, and aided government West Bengal had initially filed a suit number so-and-so before the Munsef, seeking declaration that they are laboratory assistants belonging to this category, entitled to the benefits and privileges attached to those posts, and also for a mandatory injunction directing the defendants to pay all mandatory benefits. 4. Some of the decree holder, instead of filing an execution petition, preferred to file a writ petition before the Calcutta High Court for a direction of this. The same benefit I have sought from that. Then let paragraph 8. Respondent 8, 1 and 2 herein, then filed a writ petition, which was renumbered as so-and-so, and to pay them the salary and other benefits in the revised scale. These are the facts, and based on these facts, paragraph 13. We notice that the High Court was mainly concerned with the question whether declaration made by the civil court and the respondents are class 3 employees be taken into consideration while granting reliefs prayed for in the writ petition. The High Court noticed that the judgment reached by the civil court was not appealed against by the appellants, and the same had attained finality. Further, the suit filed by the appellants against the respondents was also dismissed. In such circumstances, the High Court took the view the appellants are bound to honor the decree passed by the civil court. That is what I am praying. That's all, and I leave it to you, Lordship. If today they are allowed to dishonor the judgment and decree of the civil court and take allow them to take the same plea that they have taken in 2003. That will be tough.
Can you show me that there is any provision for regularization of the organizing
This is
teacher?
not, yes, blood, this is not regularization.
The decree, the judgment of the trial court mentions specifically that the plaintiffs requested for regularization of service. It is recorded not once in so many places.
Blood, can this court set aside that observation?
I'm not
The answer is
concerned.
no.
I'm not touching that order. You
Blood, all that I'm
get it done. I'm sorry, sir. I'm
all
not
that saying,
convinced.
if you
Please come.
allows me, blood, we can place blood orders of the government. What
No,
was
please come.
actually blood doing by the government blood at that when the organized teacher was being recognized. That I can place before lordships. The term may be the different.
Read petitions to dismiss for default. Video order dated 2nd May 2025.
And may I take leave?
Yes. The petitioners pray for recalling the same. Stop. The court. Now, since the writ petition is pending disposal since 2019, the court intended to ascertain from the parties as to whether there is any merit in the writ petition. For a merit in the writ petition, so that the order of dismissal of the writ petition may be recalled. Stop. The court has heard the submission made on behalf of the petitioners, the state respondents, and the West Bengal Board of Secondary Education. Stop. It appears that the petitioners claim themselves to be organizing teachers of a school by the name and style of Narayanpalli Madhyamik Vidyalaya. Stop. The petitioners claim to be in service since 2003. Is there a list of dates?
Claims to be in service from 77.
From 1977. Is there a list of dates?
Well, there is no specific.
Not 77, but 79, both hai. 79. The said school না ওই কি নাম বললাম Narayanpalli Madhyamik Vidyalaya was later renamed as Ratanlal Sarogi Madhyamik Vidyalaya. Stop. The petitioners sought for regularization of their service. Stop.
Petition number 2 and 4 is before your lordship.
2 and 4?
Yes.
What about the others?
So the other one has died, Miller. What has not exceeded with this petition, Miller?
আচ্ছা, one একটু খেয়াল রাখবেন, নোট রাখুন একটু, পিটিশন নাম্বার 1 has died. And 2?
2 is continuing with distribution.
3?
3, Miller, 3 no is not continuing with distribution.
আচ্ছা, 3 is not pressing the writ petition. The petitioner is being pressed by only the petitioner numbers 2 and 4. একদম উপর দিকেই লিখবেন। The petitioner is pressed only by the petitioner numbers 2 and 4. আচ্ছা, regularization of their service. The prayer stood rejected on the ground that the school where the petitioners were working was not the same school which got recognized in terms of the DLIT report. Stop. Challenging the same, the petitioners filed writ petition being WP 19347 within bracket W of 2003, which disposed of by the court. Video order dated 16th of September 2005. With the observation that the petitioners would be at liberty to approach the civil forum for redressal of their grievances. Stop. The petitioners accordingly filed a title suit before the learned trial court, being TS number 62 of 2006. Within bracket Bimal Kumar Poddar and others versus the Principal Secretary, Government of West Bengal, School Education Department and others, wherein final order was passed on 15th January 2016 by holding that the plaintiffs do get a decree for declaration that they are entitled to render their services as assistant teachers in the Ratanlal Saraugi Madhyamik Vidyalaya since January 1998. Stop. Decree was also passed by the learned trial court on 15th January 2016. Stop. Learned advocate for the petitioner submits that as the right of the petitioners to render service has been declared by the learned civil court. Accordingly, the authorities would be bound to accept the same. Stop. The judgment and decree passed by the learned trial court has not been appealed against. Stop. The same has attained finality. And the authorities, i.e. the defendants in the suit, would be bound to abide by the same. Stop. Learned advocate for the petitioner relies upon the judgment delivered by the Honorable Supreme Court in the matter of State of West Bengal and others versus Kamala Prasad and others, reported in 2010 4 SCC 568. in support of the submission that the writ court ought to take into consideration the declaration by the learned trial court. Stop. The learned advocate representing the court directed the learned advocate for the petitioner to serve notice upon the subject school, not the petitioner, upon the district inspector of schools, to serve notice upon the subject school. Stop. The district inspector of schools communicated the order to the district inspector to the Ratolal Saraugi Madhyamik Vidyalaya, but none appears on their behalf. Stop. Paragraph. Communication by the DI of schools, secondary education, Barakpur, to the school has been handed over in court today. Stop. The same is retained with the records. Stop. The district inspector of schools, secondary education, Barakpur, in his report dated 7th January 2026, his Nakori in the report 7 January 2026 has mentioned that there is no evidence of any school by the name and style of Narayanpulli Madhyamik Vidyalaya. Stop. At the same address, Ratolal Saraugi Madhyamik Vidyalaya has been established and recognized by the West Bengal Board of Secondary Education with effect from 1st May 2000. Though assistant teachers and one clerk was appointed by the managing committee of the school, but the enrollment of the students have gradually decreased day by day, and the same became zero in the year 2020. Stop. All the teachers of the said school have been transferred to other schools in the year 2021. The DI has also disclosed in the report that Ratallal Saraugi Madhyamik Vidyalaya was never known by the name and style of Narayanpulli Madhyamik Vidyalaya. Stop. Instead, Ratallal Saraugi Madhyamik Vidyalaya has been renamed as Ratallal Saraugi Ninmo, N-I-M-M-O, Madhyamik Vidyalaya by the West Bengal Board of Secondary Education in the year 2006. Stop. Upon hearing the submission made on behalf of the parties and on perusal of the documents placed before this court, it appears that the judgment and decree relied upon by the petitioners is an ex parte one. Stop. The learned trial court took note of the fact that the petitioners, plaintiffs before the learned civil court, sought for regularization of their service. Stop. according to the education laws currently governing the field in this state, comma, there is no scope for regularization of service of organizing teachers. Stop. The fact of renaming of the Narayanpulli Madhyamik Vidyalaya to the Ratanlal Madhyamik Vidyalaya is also disputed by the Ratanlal Saraugi Madhyamik Vidyalaya is also disputed by the District Inspector of Schools. Stop. The DI has recorded that the school does not have any student at present. Stop. The teachers of the said school have also been transferred to other schools. Stop. At this, in the facts and circumstances as mentioned herein above, the prayer of the petitioners for grant of service benefits in the Ratanlal Saraugi Madhyamik Vidyalaya cannot and does not arise at all. Stop. The writ petition accordingly fails and is hereby dismissed. Stop. The impugned order, no, not impugned, the order of recall dismissed on merits. The order dated 2nd May 2025, however, stands recalled. Can disposed.
Item number 156.
My lord, I'm appearing for the alleged contemner number 1, my lord.
Lordship, I am appearing on behalf of the Director of Pension and Provident Fund, Lordship. Lordship, last occasion, kindly see the last order, Lordship. PP has been issued, Lordship.
My lord, I was directed to file a report regarding the qualification of the TIC and the disbursement. My lord, I have the report is my.
You are for the school.
My lord, the alleged contemner, the DI Malda.
All right. Did you receive all your benefits?
Nothing, my lord.
Nothing.
My lord, they have not supplied us with any.
Everything has been completed, my lord, as per your lordship direction.
They means who?
My lord, the petitioners, the deceased legal heirs, my lord. If my lord comes to para 5, we have stated, my lord, that they have not provided us with the bank accounts, my lord. They are
the deceased teacher are
the
directed
deceased
to
has
render.
5 children, my lord. They have not provided us with the bank account, my lord. And my lord, it's a meager amount. We have no interest to keep their amount pending. It's a very meager amount, my lord.
Where are the bank account numbers?
My lord, I have given all the particulars to them, my lord. Even, my lord,
Show me, please show me. Please give me the bank account numbers.
Right now, my lord, I have no bank account number right now, my lord, but I have given the other legal heirs also given their objection. No objection.
My lord,
Not a matter of no objection. Where will the money go? The money will go to the bank account. Where is the bank account number?
Then, my lord, can you kindly give me 1 week time? In the meantime, I will furnish the bank account to them.
Did you seek for the bank account number? Show me some document that you sought for the bank account number.
My lord, the report I have given does not contain. My lord, the report I have submitted.
Yes,
there is no such annexure. I'll have to ask them because they had
It
told
is
me.
your submission that the petitioner has not provided the bank account. Show me that you sought for the bank account number.
My lord, that annexure is not annexed. My lord, keeps it next week. I will bring that document.
It is your submission.
My lord.
Relying on which did you make this submission?
My lord, the report para 5.
This is the report by whom? The DI?
My lord.
All right. Mm,
Admitted. One.
in the report, paragraph 5, there is one annexure, 16th of December 2025.
My lord, this is our internal minutes, my lord. And my lord, that my lord comes to my lord's order 13th November 2020.
1 minute. Have you come to the report?
My lord.
Paragraph number 5 you are relying upon? See the last paragraph in paragraph number 5, copy of the memo number 231.
My lord.
Where is it? Is mentioned is enclosed herewith and marked as annexure R3. Where is that?
My lord, I guess I've missed it, my lord.
This is the DI's report. You do not have anything to do with it.
My lord,
So when it was forwarded to you, did you not check? It was 31st of December 2025.
My lord, it is just received today. Instead, they've given our internal meeting resolution.
It was not required, isn't it?
No, my lord.
I do not know whether it has been referred to or not. But then the document which is required
That is not on.
is not there. What type of a report does the DI file? Did the petitioner receive any such communication?
Nothing, my lord.
Your client did not intimate you.
No, my lord,
My
nothing.
lord,
He has not received, my
my
lord.
lord, as per the
That
order
is-
dated 13 November 2025, my lord, para 5 and 6, the direction was on the school to get the documents and forward it to us.
Yes.
But the school did not appear on the last occasion. Today, I found my lord.
Yes.
Para 5 and 6.
Para 5 you are going. Para 4. The DI is directed to take all necessary and effective steps to ensure. What steps? If suppose the madrasa doesn't take steps, you are the DI. Will you not take steps to see that your teacher gets the retirement dues?
My lord, gives a 1 week time, my lord, I will find.
Please come.
In the meantime, if I will not submit my account number, but I will submit in the meantime.
Report of the District Inspector of Schools, Secondary Education, Malda, dated 31st December 2025, filed in court today, is retained with the records. It appears therefrom that the details of the bank account of the bank account of the legal heirs of the deceased employee have not yet been submitted in the office of the District Inspector of Schools. Stop. Next. Though the District Inspector of Schools, in his report filed in court today, mentions about a communication dated 16th December 25 addressed to the legal heirs of the deceased employee for furnishing the relevant documents for taking steps to disburse return dues, the said communication dated 16th December 2025 has not been annexed to the report. Stop. Learned advocate representing the DI seeks time to obtain further instruction. Stop. Hearing of the contempt application stands adjourned till 29th January 2026. Stop. In the meantime, the petitioner shall forward the bank details and other relevant documents to the District Inspector of Schools so that the terminal dues can be disbursed without any further delay. Stop. If any further document is required from the end of the petitioner, the same shall immediately be communicated by the DI to the petitioner. Stop. It is made clear that if the madrasa does not cooperate with the District Inspector of Schools, then it will be the duty of the DI to send representative to the madrasa for collection of necessary documents for the purpose of disbursal of terminal dues of the deceased employee.
Grateful, Lords.
Item number 157. This is the review application filed by the state authority. Well, actually, Shishano Bandyopadhyay is appearing in this matter, my lord. My lord, your lordship kindly adjourn this matter for 2 days only, my lord. Well, he is arguing in another court, my lord.
But I appear for the writ petitioner respondent.
Last occasion also I see recorded.
Yes, under heading contempt, that matter was.
Whatever, but then accommodation was sought for.
No, my lord. Your lordship, earlier occasion, your lordship direct me to serve the copy of the review application to my learned friend, and
the petitioner is alleging violation of the direction of the order in September 23.
And I am not getting any salary.
My lord, prior that review application has been filed, my lord. Regarding the scheme, my lord, your lordship kindly record the matter, my lord. My lord, scheme was already revoked by the central government.
Well, that is not the fact. I have filed the exception to this review. But I have annexed the document that the still 2026 April it is in force.
Not 6 April, 25 April.
No, 2026 April. The scheme of the government is still in force.
2026 April means what is the date?
Well, 2022 to 2026 for 4 years.
So it's still valid?
Yes, still valid. And we are entitled to get the salary and other benefits.
Well, actually, kindly adjourn this 2 days only. Well, then.
If Mr. Banerjee is in difficulty, I have nothing
only
to
not
say.
today.
Yes. Grateful. Well, let it return in his position.
It will be there.
Grateful.
Next.
Petitioner কোথায়?
Petitioner is not appearing.
Petitioner is not actually
Order has been complied with.
complied, but I will come with a report.
Very well. Dismiss for default. Next. None appears for the petitioner. No accommodation sought. Dismiss for default.
Our appearance, that
Certainly, certainly.
Lordship. 159, I beg to appear for the petitioner, Lordship. Lordship, by the last order, your Lordship was pleased to direct the respondent that all terminal dues of the deceased employee shall positively be
I am
cleared
explaining.
prior to the adjourned date. Thereafter, Lordship, the gratuity has been paid, but arrear pension and leave encashment is remaining.
Only one
defaulted.
thing. My lord, everything has been paid. Arrear pension, my lord. Actually, fact is that, my lord, the software problem they have applied for on November last week. We will surely pay it by this month.
It is only the leave encashment and
the arrear.
arrear pension.
Arrear pension.
They will pay. All right. Please come. All right. Learned advocate for the petitioner submits that though gratuity amount has been released, comma, but the
gratuity is released, madam.
arrear pension and leave encashment amount is due and payable. Stop. Learned advocate representing the contemner / corporation submits upon instruction that the same will be released shortly. Stop. In view of such submission, released the contempt application for further consideration on 19th of February 2026. Affidavit of compliance shall be filed on the adjourned date. Next.
19th of February legal.
I am appearing for the petition of my lord. On earlier occasion, my lord, the corporation said that some portion of the unauthorized construction was remaining. My lord.
What happened thereafter? Did demolition take place?
Challenging your lordship's order. my
My
lord.
lord, this is
You
my
preferred?
photograph.
No, not me. The person responsible for
Person responsible.
pending, my lord. Yesterday it was taken up, my lord, by the honorable division bench, my lord. However, my lord, it was made not today on that particular date. So today it is running in the list. I believe, my lord, tomorrow it might be taken. In the meantime, since there is no stay, my lord, we have proceeded further with, my lord, demolition. Some, my lord, considerable amount portion of the
No, that is recorded in the last state's order.
Thereafter, on 9th of December, Millard, we have demolished some portions of the remaining unauthorized structure. Only, Millard, the difficulty, as it was, Millard, recorded in the earlier order, Millard, that the structure, Millard, since it is very old structure, some portion which is, Millard, part of, Millard, the recent order, Millard, if we try to demolish the entire thing, then, Millard, the rest of the, Millard, portion, Millard, it might be affected and the building, portion of the building might collapse. So this is the reason, Millard, we could not give full effect to the entire recent order. However, Millard, major portion of the recent order has been complied with, Millard, on 9th of December, Millard.
Millard, the photograph is the current photograph has been placed, my lord, given. The corporation was needed to be demolished as per the sanction, as per the unauthorized construction plan provided by the corporation.
Is this the unauthorized construction?
This is perhaps, Millard, the old. Thereafter, Millard.
Millard, it was date and time has been released.
Yes, 10th of December, because 9th you took the demolition took place.
Millard, the report with me, but unfortunately, Millard, since the photograph is, Millard, a colored photograph, Millard, I could not, Millard, take out. I have the.
Is this the unauthorized construction?
Yes, my lord.
So it's completely standing over there.
My lord, the cantilevers and the, my lord, the wall or ingress is still remaining.
Only cosmetic demolition has taken place.
I have.
See the photograph?
I have some photographs, Millard. Let me, Millard, open it, Millard, in my time, if your lordship
Yes.
allows me, Millard.
See, the ground floor wall appears to be an old one.
Millard.
But the structure on top is absolutely new.
May I, Millard, verify with my. Millard.
Check.
Kindly have a look of the sketch map provided by the corporation.
This sketch map?
Yes, madam.
What is to be seen?
Millard, this is, Millard, perhaps apart from the contempt application, the writ petition, Millard, pursuant to which the contempt has arose, Millard, it is perhaps the third round of litigation. There was a specific litigation, Millard, which was, Millard, considered by your lordship, Millard, directing, Millard,
the corporation to provide the sketch map. We have provided the sketch map with marked with the entire unauthorized area. It was given to both the parties, not only the petitioner, the
Person responsible.
but also the complainant. So today they are again seeking in the contempt jurisdiction. If your lordship directs me,
What he is seeking? He is not seeking anything.
I'm sorry.
He says that you have provided the sketch map where the unauthorized portions are marked.
I have the photographs, Milord. This is Milord.
Yes, see the photograph. The structure is completely there.
According to my instruction, Milord, this is not the Milord
Unauthorized portion.
Whatever
All right.
portion, these cantilevers and these Milord pillars, they are remained Milord. That is needed to be demolished, Milord. But if we attempt to demolish the entire thing, the entire
And the yellow portion is authorized.
This thing, the wall is Milord within the authorized area.
Wall is authorized.
This is what I have been told. Now, Milord, this portion, if
Yes.
I try to demolish it,
Yes.
the wall might collapse. Milord, we have filed a report, Milord, on Milord.
Tell me one thing. This wall, there is a structure behind that, right? Is it a room?
It is a room. It is a room.
Is the room authorized?
It is.
Is the room authorized?
I'm sorry, Milord, the room is not authorized because
If the room is authorized,
also
not
a Milord portion Milord which has been demolished.
right.
That is
Now, if the room is unauthorized, the same picture the petitioner is also showing. If the room is unauthorized, so you are required to demolish it.
If we try to Milord demolish entire thing, Milord, the authorized portion, Milord, if there is a plan, since the building, Milord, is a very old structure, Milord, it will automatically collapse. Now, Milord, we are Milord very much afraid, Milord, if something untoward incident happens, Milord.
So it was at the risk of the person responsible for making construction who took this risk.
It was already recorded in your lordship's order, Milord. I absolutely bow down to your lordship. But we as an authority, Milord, we cannot, Milord, take the risk, Milord. If something happens, Milord, tomorrow they will come and hold us, Milord. Thereafter, Milord, your lordships is there, Milord, to protect us. I understand, Milord. But kindly, Milord, consider this fact. If we try to attempt, kindly, Milord, direct them because they are, Milord, the person responsible, the appellant, Milord. So, Milord, kindly direct them, Milord, with a stipulated period. If they fail to, Milord, demolish their unauthorized structure, Milord, then we have.
They have already failed, sir. You are the corporation. You are unable to do it, and you think the person who made the construction will demolish it.
Structure, Milord, has two parts. One part, Milord.
Sir, I am not concerned. It is your sketch which has marked the portion that is unauthorized. Proceed to demolish that. It is as simple as this.
Well, but in view of the pendency of the appeal, Milord, kindly, Milord, record this also, Milord.
Please come. Learned advocate representing the petitioner submits that portions of the unauthorized construction still remains. Stop. The learned advocate representing the contemner / corporation relies upon the action taken report signed by the engineers of the corporation on 10th of December 2025, mentioning that the subject building is a two-storied residential old structure. As per the sketch map prepared by the corporation, the demolition team of the corporation partly demolished the unauthorized projection at the side and the front open space and the wall over the projection, the facial / front railing over the unauthorized projection and also the railing over the roof. Stop. According to the corporation, further demolition may result in collapse of the existing structure, which is an authorized one. Stop paragraph. It has been brought to the notice of the court that the person responsible for making unauthorized construction. has preferred an appeal before the Honorable Division Bench.
That the portion which is authorized, which is not part of the recent order, my lord, because this is a part, my lord, where the construction was made in the Rajarhat Gopalpur period. My lord. Your lordship understands, my lord, the predicament, my lord, on that part. Kindly not record the authorized word. Kindly record.
I will not record the
Kindly
authorization.
record, my lord, which is not part of the recent order, my lord.
কি বললাম আগেরটা? Existing structure stop করে দিন। ঠিক আছে? আচ্ছা। তারপর কি বললাম? And the same is likely to be taken up for consideration shortly. Stop. Next. It has also been brought to the notice of the court that as on date, there is no order staying operation of the order which the petitioner seeks implementation of. Stop. Paragraph. Learned advocate for the petitioner has produced the sketch map provided by the, not sketch map, but the sketch provided by the corporation marking the unauthorized portions. Stop. Paragraph. The corporation is directed to take steps for demolition of the portions that have been found to be unauthorized. Stop. As the person responsible took the risk of making the unauthorized construction over the existing old structure, the said persons have to face the consequences if the old structure, now if any damage is caused to the old structure at the time of demolition of the unauthorized one. Released 19th of February 2026. Affidavit of compliance shall be filed on the adjourned date. Do you have a photocopy of this sketch map? You can take it back also.
Kindly take it in the first week of March.
Why?
Some personal difficulty in that week of February, particular that.
26th of February? Achha, these photographs?
Photographs, my lord, may be kept with the record, my lord. I will take out another photograph.
Achha. These are paginated. You took it out from somewhere or what?
No, my lord. My lord, it was wrongly paginated in another, my lord.
Oh. Photographs গুলো রেখে দেবেন। Take this back. এটাকে ফেরত দিয়ে দিন।
Grateful.
$161.
I beg to appear on behalf of the petitioner. Lordship.
Yes.
Page number 18 is the Lordship direction, where certain direction has been given by Lordship. Can you hand it over one?
Are you aware of the hearing before the special officer?
Lordship, as such, I have no instruction, but there is an order in September 2022, Miller.
No new construction. There is sanction from G+4. 21, paragraph number 3, I see that the special officer building passed an order in July 21. We are in January 26. No steps taken.
Lordship, my lord's direction was to complete the hearing. That we have done. Subsequently, your lordship, this portion, my lord, I have also sought for the relevant instruction that the person responsible could not produce the fire document. That is the reason the matter has been stalled, your lordship. To that effect, I'll come up with the appropriate instruction what has been done till date. Because your lordship, the direction work, my lord, was to conclude the proceeding before the special officer building. Lordship, to that extent, lordship, we have complied.
Where is it? Where is the final order?
Lordship, that final order, the hearing has been, Lordship, a hearing conducted before special officer and passed an order on 16th July 20. Lordship, that order has not been annexed. I can come up with the order, your lordship.
Listen, the court passed order in 2022 and you are relying upon an order of 2021 and you say that the court's order has been complied with.
Lordship, subsequently, your lordship, the hearing was also done.
No, I do not understand. The court passed order in 2022. Show me the order has been complied with and where is the order of the special officer?
Lordship, I'll come up with the appropriate order of the special officer, your lordship, because the paragraph 3, the content of the paragraph 3 is not fully satisfactory, your lordship. I'll come up with the relevant documents, your lordship.
3 of your engineers, they fail to understand what the court said, what they are supposed to do.
Lordship, the instruction that I have received, your lordship, the special officer building was incessant with the matter, was conducting the matter. Subsequently, your lordship, the order was also passed, but we couldn't get the order. I'll come up with the order. My lord, give me 1 week time, your lordship. I'll come up with the order, the subsequent development.
Now your officers should be put to costs. Otherwise, it is becoming absolutely impossible to manage the list. Have you seen the number of contempt applications that are pending?
Lordship,
the order is of the year 22 and you still want time to come back.
Lordship, this portion regarding the
I am not concerned with any portion. I just want to see that the order has been complied.
Lordship, it is for the special officer building to comply.
Tell me that it has not been done or it has been done. Something should be said.
Lordship, appropriate.
That means I am to adjourn the matter for another day. And the list goes on. And every day in the morning, these contempt matters are being mentioned and the court is unable to help because of this type of assistance from your officers. The moment I put them to costs, you see things will reduce.
Lordship, special officer building ought to have given the forwarded the order. Lordship, I'll come up with the appropriate order.
In 2022, the court records that the matter is pending consideration before the special officer. Even in 2026, you come up and say that the matter is pending before the special officer. What is the court supposed to do? Will you please say?
Lordship, the matter is not pending, but special officers might have been transferred also, but not for some time, Lordship, there has been some gap here, Lordship. I'll come up with the appropriate order.
Please come. A report signed by 3 engineers of the corporation building department, Borough 3, on 10th December 2025 has been filed before this court. Stop. It appears therefrom now. It is mentioned therein that the demolition case file is under hearing procedure for conclusion before the special officer within bracket building. Stop. The petitioner alleges violation of the direction passed in the order dated 28th of September 2022. Stop. The court recorded the submission of the learned advocate representing the corporation that unauthorized construction had been detected and the matter is presently pending consideration before the special officer within bracket building. Stop. It is absolutely unacceptable that The matter, in the year 2026, is still pending consideration before the special officer building. Stop. The commissioner of the Kolkata Municipal Corporation is directed to file a report disclosing the manner in which the authority took steps for compliance of the direction passed by the court on 28th of September 2022. Released 12th of February 2026.
Number 162 and 163.
Yes.